morning, everybody. Welcome to, or wait for the charge conference. Jury instructions, order of the business today. A little bit of a surprise. That we're here doing this today. I think we had expected and kind of been led to believe we'd be watching a rebuttal case right now. And the fact that we're not has created some kind of interesting questions and possibly some issues that they may deal with in court today. The most obvious one of which to me is that the Commonwealth never got around to calling Terry Kuhn, the UC Davis DNA analyst who tested those. Now I don't even remember if they were cuttings or swabs. It was swabs around the sleeve, John O'Keefe's right sleeve on his sweatshirt. Did DNA testing, found no dog, but there was some pig. And Dr. Russell was allowed by the court to be cross-examined about it by Hank. But there's an issue with it because it's not an evidence. And there's a long body of case law talking about the right of the criminal defendant to cross-examine DNA analyst, somebody that's doing testing in the case in anticipation of presenting it in court. That is testimonial hearsay under the confrontation clause jurisprudence. So that's a problem. It's a problem that jury's heard about it. It's in, they know about it, but it's not in evidence. And the defense never got to cross-examine the DNA analyst about it. So because of that, we might be seeing a defense request for some type of jury instruction there. Disregard, perhaps. But that might be awfully hard to do at this point in time. Dr. Russell is quite a few days ago now, and part of the problem is, she acknowledged this evidence. She agreed, aware that there is no dog DNA that was found. So maybe we just leave it. No, but it's a lurking issue that remains unsolved, that at least in theory was going to be cured by calling Terry Kuhn in rebuttal, put her up for cross-examination. But the decision not to put on a rebuttal case has taken that off the table. Well, Hank sure quit, didn't he? What a quitter. What a quitter. Champ at all. No eye of the tiger there. He got a little bit rocked and he was done. He was done. Not much of a champ here. So, it looks like the stream is glitchy. Uh-oh. Let me, guys, let me get out and get back in and see if that fixes anything. Okay, guys, I'm back in. I'm not sure if this is us or if things are just kind of glitchy all over. So don't know if that's any better for you guys. Just check it out and let me know if things get weird. But I'm not sure that it's us. We are having a big windstorm over here, which is not uncommon. Not uncommon at all. I think there's wildfires too. I smelled a little bit. Went outside this morning to do my chores. So things like that can, sometimes get in the way of the old inner tubes, the old series of tubes. Make it things a little bit, a little bit annoying. So if it's happening, sorry guys, I'm just not sure that there is going to be anything I can do about it. But the stream is over there in Dedham, ready to go. So we will be getting over to the jury instructions soon enough. So let's talk about the jury instructions because, boy, it turned into quite an issue in the first trial for all kinds of different reasons. So Massachusetts, like many states, Massachusetts has form jury instructions. So these are usually created by a committee, judges, lawyers, practitioners, things like that. They get together and they just make recommendations. They come to a consensus on what's the best way to explain the law on all of these different subjects to the jury, reach a consensus, and they adopt these forms. And because it's, by committee, there's kind of this general expectation, understanding that they're usually going to be right. Now they're not always. Okay, we challenge form instructions all the time on appeal. Sometimes we win. Sometimes the instructions don't get it right. But most of the time, it's a safe thing to do to just go ahead and give the form instruction. They are not mandatory. They're not mandatory. You don't have to give them, but you eliminate a lot of risk that you'll give the jury correct instruction on the law and then create an appeal issue most of the time if you go ahead and give the form instructions. Now last year there were several that behave where she does not follow the instruction, the form instruction. She has her own little script that she likes to give. I think she even announced during the conference that's what her practice is. Got some of her own, and other ones are form, but it can make things a little bit sticky. Can make things a little bit sticky. We had an issue last year with the verdict form. The verdict form for the voluntary manslaughter charge for count number 2 did give the jury the option to acquit on the lesser includeds. It was convict or nothing. So not a good way for the jury to be able to indicate if, hey, we've ruled out voluntary manslaughter, we've ruled out the first lesser included, and then we get to the final lesser included and we can't agree. There isn't a way on the old form to be able to indicate that, and that ended up turning into a little bit of an issue. So don't expect that to recur, right? It shouldn't. You've been on notice for been on notice for a year that this was an issue. And if you were watching when all that came up last year, you'll remember that the defense objected. Remember, the defense objected to the instruction. She's like, I'll think about it, look at it overnight. And then we come back into court to address it again. And they remind her, we got to deal with the verdict form. She's like, well, I was tired. I didn't get to it. I was tired. Bev was too tired to make sure that the jury had an appropriate verdict form. But then I guess at some point she did change it. She changed it unilaterally without the input from anybody, sent it back to him, and the defense is like, this doesn't address our concerns. Real mess. So given that process last year, we would think you're on notice. You're on notice this time that there could be a little bit of a problem. Try to sort that out. So there's general form instructions for the process, the general legal principles, reasonable doubt, burden of proof, all type of thing. There's form instructions on what we would call the to convict stuff, the actual formal elements of the charges and things like that. And then the defense and the Commonwealth can both propose their own independent instructions. They have done so. We have looked at a little bit of that. One of the things, I've got several things up here in my tabs. I've got the Commonwealth, the defense proposed. I've got several, there's like form instructions in different places. There's one in particular I'm going to pull up to share with you guys because I saw some conversation about it on Ye Olde X morning. And so I want to highlight it for you because I suspect she'll probably give it again. People want to know, last year, Bev talked about the straw poll. He told the jury, you really shouldn't take a poll before you start deliberating. People said, what's that about? Doesn't seem appropriate to tell the jury how to do their job. Yeah, it really doesn't. But here's why she did it. It's a form instruction. It's a district court form instruction. So it's not, if you're just looking at we're in superior court. If you're just looking at superior court instructions, you're not going to see it. But there's nothing about it being in district court that inherently makes it inapplicable. There's quite a few that got pulled from the district court form instructions and given. And so that's this one. This is what she gave. She tells them, sometimes it makes good sense not to put the case to a straw vote, but you get into the deliberation room because then sometimes jurors get invested in defending their vote without having had the benefit of deliberative process. I suggest that you deliberate on this case, review any documentary evidence that you will have with you in the deliberation room, and discuss this matter with your fellow jurors before you start putting the case to a vote. As I said, that is simply a suggestion, and you are free to deliberate in any manner that you wish. And there's just this other stuff about, don't use your cell phones, can't do research and things like that. So I'm so intrigued by this form. Now we see that there's a note here. This is very common with the form instructions. You'll have a note that tells you, here's the case law, here's the rule, here's what the legal source is for why we're giving this particular instruction. And so we got sources about, don't have cell phones in there, don't use them, don't use the internet and stuff like that. But there's no at all for this. I suggest you don't take a straw poll. As far as we know from this form, there's like no legal basis for this at all. This is just something that the committee that puts instance together has looked at and decided that, this is good practice. This is what the jury should be told. But the problem is that this really is getting into interfering with the deliberative process and micromanaging it in a way that really isn't contemplated. It's problematic to be interfering in the jury room and in controlling the process. So I did want to share that just so we all know that's where that came from, guys. That's why she gave that last year. And my expectation, she'll probably give it again this year. If it's one of her routine ones that's in her script that she'll give, that's why. Now, like I said, it being a form instruction doesn't mean that it isn't subject to challenge. You can challenge form instructions, and sometimes they're wrong. Form instruction that really doesn't even have a citation, doesn't even have a basis for why we're telling the jury how we think you should handle your business back there in the deliberation room. I don't know about that. I don't know. So it's not an issue that I've researched extensively. Looked at the case law on what you do and don't get to do as far as telling the jury how to do their job. Uh, but it just doesn't sit right to me. It smells off. It smells a little bit off. It's like when just not quite right. You have that sense, and it's just because one, there's always problems interfering too much with the jury because of the risk that you influence them, that you know subtly or not pressure them in the direction that you want to go. But also just because that jury process is sacrosanct. This is one of the oldest premises of the jury system at all. Among the form instructions that can be given to the jury is instruction that the deliberations are confidential. They're not supposed to tell anybody about them. That's not against the law if they do, but they're just strongly encouraged. Don't talk about things that other people in the jury room. It's bad form. We don't like it. What goes on in the jury room is supposed to be sacrosanct, and that's really because it's up to them. This is our time now, our role in this process. We, the people, the ordinary people, going back there and doing what we think is right to get the right outcome in this particular case. And so this urge to micromanage that just really doesn't sit well. I'm not sure that that's particularly well grounded legally. I don't have case law to say that it isn't. I see a form instruction and I see no legal support for that at all. So it really does make me wonder. We looked a little bit at some of the proposed instructions, I want to say over the last few weeks. And so one thing that has stood out, let me go ahead and while we're waiting, I'll bring the Commonwealth's proposed instructions up here. And we can see what it is that they're looking for. If you guys can see yet, is it still glitchy? I think it might be still a little bit glitchy. And so if you guys can't see things well, I do apologize for that. But it's just kind of where we are right now. So this is what the Commonwealth is asking for. A couple of things that stand out. Okay, so murder in the second degree, we already know that. We looked at this before. I don't like how they have this highlighted with the other options out there. If this is the theory that you're going on, the intentional act that would create a plain and strong likelihood that death would result, then you just don't give them the other ones. You just don't get the other options. We have, I haven't looked at the case law in Massachusetts for this either. In Washington, we have this doctrine, this alternative means, we call it. If there's more than one way to violate a suit legally, then you only submit alternative means to the jury if there is sufficient evidence in the record to support giving that alternative mean. If there isn't, then you don't give it. And the reason why is because the jury isn't going to be asked to decide which specific one of these sub-elements has been met. So you run into a risk that the jury isn't unanimous on it. Some of them, well, I think she's guilty of subsection C here, the plain and strong likelihood of death version. And other people think, no, I think she intended to harm him. And you don't have unanimity on the means, the reason why you think she's guilty. Don't know if they have a doctrine like that in Massachusetts, but it just stands out to me here when they're, calling out this specific one. That seems to be implying you're not relying on these other ones. If you're not relying on these other ones, you really should just take them out of the instruction altogether. But that's not consistent with, Hank's approach. I think he wants to just have the shotgun, leave every option open if possible. The manslaughter, we've got the manslaughter instruction. We talked a little bit last time about how Plain and strong likelihood that death would result. This is like almost indistinguishable from manslaughter. Manslaughter, high degree of likelihood that substantial harm will result. Okay. You tell these things apart for me. High degree of likelihood that substantial harm will result. Plain and strong likelihood. I don't know. So anyway, we have the manslaughter charge. He wants, in this one, we're noted that we want both theories, operating motor vehicle, both just under the influence and or with the 0.08 blood alcohol or higher. These again, alternate means, different ways of being able to establish this particular element. We similarly in Washington, per se, you have a per se limit for driving under the influence, 0.08, but you can also be guilty just for being under the influence without any proof of alcohol content at all, just based on proof that your driving was affected. So they want both. That's fine. But what stands out about this, there's like so much detail in all this stuff. It's kind of ridiculous. Look at this instruction to know if you want to find her guilty of manslaughter. 1, 2, 3, 4 pages. 4 pages just on manslaughter. I don't know how the jury is supposed to pay attention and follow all this. Well, but what stands out about it to me, it looks like they're getting started in court. What stands out for lesser included. It doesn't look like. So that's different from last trial.
Please. For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your
Good morning, Ms. McLaughlin.
Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler was entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification and your rights are saved on that. Ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can't now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these 3 indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches, I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely
not.
Karina Kolakifis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response. The same Brian Higgins whom Karen had given her back all night. The same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video. The same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins. Yeah, the same Brian Higgins.
Oh, she's listening.
Who was on video, hot,
Good
angry,
job,
and
Bev.
gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Laughlin, following Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Laughlin confirmed that John O'Keefe was not on the front lawn at the residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right, thank you.
Lally.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there.
Link also said no dog.
Arguments from counsel, the
Nobody
Commonwealth would
heard the
suggest
dog.
grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCCA witnesses testifying about superficiations. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a bus. The same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drive the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and request that the defendant's motion be denied.
What a bizarre interpretation of the evidence.
You know, I have to view this in the light.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay.
We knew that was
All
going to
right.
happen.
So regarding the charge, so we'll start with the defendant's missing witness request.
Yes.
Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night with 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing?
With regard to the absent witness instruction, we're withdrawing that request.
Okay,
Drawing.
and what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost exploited evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right. Filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Leslie.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth?
I am.
Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request, and I understand that the court's position might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking instruction on murder column.
All right, so we will deal with that. I'm
Very
going
hard
to
to
go through
hear.
the defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I
Is
will
it?
give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it still clear though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give from what you have. I'll take a look at it, but I will certainly cover all these topics. So Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth will be making similar requests that counsel will be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from defense, from actual evidence in the case, from testimony from witnesses to the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and argument,
Because she kept out their expert.
Obviously, the court is well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not
What
only
a shitty argument.
instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials, packaged evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias, the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct. He's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And responding briefly to Mr. Lowry's comments about how being introduced affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion in.
They did.
Asking for reconsideration of the ruling that Mike Easter could not testify about an investigation. So
Right.
to say that we didn't introduce that evidence when we tried to do it, we were
I think what Mr. Lally was saying, that you asked questions but given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert.
Correct.
So that was separate, but I did say that I would give you the opportunity and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you can argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's crystal clear, Judge.
Okay.
Right, and that's really what I was seeking, was clarification based on.
Yeah. So Mr. Yannetti, and if I take him at his word, tells me that they're not going to do pure third-party culprit.
You're not.
Okay, that's great. That makes that easier. So I will give,
Interject, I'm sorry.
sure, go ahead.
Just while we're on page 8, I just wanted to, Commonwealth has an objection to the instruction that's at the top of the way data.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have. It does not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a record, even on their own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation.
It wasn't.
We had
Dave, good try, but it
officers
wasn't.
who, refused to sit down in the living room. They were surrounding her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Hill?
if I would also add, Mark,
Sure.
they did seize her vehicle around the same time.
That is
So,
true.
That it goes to the issue of custody, and my client being denied.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any sort of cordial situation. She was taken into custody, she wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed from the course of the day and from statements from Ms. Reed herself. But I don't think that informs that conversation or interview in her parents' living room.
into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions or requested main practice. And then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding your compromised mental state and all of these other things that, while if it were to be given, court should be given in the same context.
Hours before.
If they want any details. And then when the questions became centered on, or more centered on details, at that point, and I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that it rises to the level of these instructions. So I would ask basically that everything on page 8 prior to the relevant instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And if you want, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the.
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even my.
Basically, she's not going to give any of their instructions.
Cut down the time.
Seems
the
to be
jury
what
needs
she's
to
saying.
hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on?
16.
Okay.
One suggestion there was indicate now Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. evaluating the evidence. There's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe,
Did we hear about Aruba?
as to
Is that from the kid?
his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, we're looking to Aruba. We don't believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
Gave contemporaneous instruction regarding the text. Yeah.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call on that.
Okay. All right.
Withdrawing it.
All right.
After all that.
So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up. Okay.
Your Honor, Commonwealth's request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors. So
Good. You should get rid of the other one.
the Commonwealth view the first two prongs are essentially strangers in this situation, and don't explicate them to avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to grieve father's harm. She's not intending to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I got a question about
I
it because
could
it doesn't
say
seem to correspond to the
The
indictment.
parties agree that the first prong and the second prong are not applicable here?
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement.
That's correct. You shouldn't. There's no
If you can
agreement.
get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's
Give you
just
all kinds
the
of stuff
third
from
prong,
Washington.
and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
And that's really the only reason for this. But I understand, and I don't consider it complicated.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe.
I would be fine.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the count.
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen,
Okay.
but we can see. All right. So lesser included offenses. Did you want to know UI instruction? You were
We're asking for that.
okay. All right. Right, I think that's it, aside from Mr. Lessie's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on the redaction subject to the court's ruling,
Okay,
but it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on 1 second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Leslie.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so we
Okay.
redact it. It's on a thumb drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
Passing,
And then,
passing around.
will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, and I hand the
Okay.
proposed copy to the court.
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually United.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least, it's like three of the charges, including the main charge, because there's this issue of either under the influence or .08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the board is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports the defense requests it, that the board must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the board's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Law, in which he had similar issues. I believe
use at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that we instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court copy with a copy of the docket, but that may be somewhat helpful with the court system.
Okay, was that on murder case?
It was not, but it had to do with a felony motive homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy, please?
sure.
This is the,
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
it's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the consciousness of guilt instruction. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in his argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are so this is within that that we'd like to make some argument to the jury regarding is the defendant's taking of the Lexus from when Metal Tavern came to her parents' residence indictment, and then certain statements made in reference the various flips of the way of her statements.
Okay.
In particular, would be the one where essentially she says it's authenticated to her.
Okay.
Whatever the exact.
Can't hear that at all.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video
But you
clips
can't.
that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the reductions.
that's great. Thank you. One less thing you all have to do today, okay?
This is Mr. Lewis.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before?
We're just going to move labels around on things.
The redactions on the Higgins messages, that's
What a mess.
what you're saying you're fine with, right?
Proctor communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just, 209, is everybody in agreement that it's Exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep
You do.
record of the first one that was
Indeed
not
you do.
redacted. So any objection to making this 209A?
I have no objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
I-
Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that,
Okay.
right? 'Cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So then
our thinking is it needs to be sent back to letters for ID.
Yeah,
So it'll be marked MM for ID.
that's great.
Perfect, and then the redacted version will now just.
209.
Yes.
Yep.
This is why you handle this stuff before you put it in evidence. No, we'll just move labels around and stuff. What a mess.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's appropriate instruction to give in the final charge.
Lally hates Brennan.
Contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Leslie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Laboratory, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not
The
objected?
testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally,
Very briefly, Your Honor.
keep your voice up. please.
Yes, very briefly. I'm not going to get into a belabor of the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen, mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay, so I'll consider it, Mr. Alessi. Okay.
Thank you, Your Honor.
All right, anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things, to ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during the deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning.
Sure.
We'll counsel here at 8:30. All right, thank you.
All right.
8:30 tomorrow.
I gotta
Is there already one of those? Like, are we swapping?
Yes, there's
Goodbye.
Look at them. They're still in a mess about what evidence is what because you're swapping things out and moving labels around and so forth. Oh my God. Early day tomorrow, guys. Oh, okay. What's our bottom line? What a freaking waste of time. What a waste of time. Oh, it's so annoying going through this jury instruction conference where we're walking away and we still have no idea what's being given and what the wording is. We have absolutely no idea. This is part of what created the mess last year and the problems with the instructions, and then she had to go fix it, and then she's getting pissy because she's tired. What happens in a professional court? What happens in a professional courtroom is that regardless of who puts the instructions together, some places the judge proposes the whole set of instructions, some places the parties propose whole sets of instructions, some places like our general practice here where I am is the prosecutor proposes a full complete set of instructions, and then the defense will object or propose any additionals that they want. But we typically try to discourage the defense attorneys from offering a full set of their own instructions. It's not against the rules, but for appeal purposes, it's just better that they don't because it's potentially inviting error for any type of instruction they may ask. I just said at the beginning, sometimes the form instructions are wrong. So if you're out there requesting it, it's a wrong instruction. But if you've proposed it, it's an invited error and you can't appeal from that. Regardless of what jurisdiction we're in and who is responsible for proposing the jury instructions, the purpose of this freaking conference is to have the draft done so that we all get to look at it and we get to state our objections or exceptions on the record to what is actually being proposed and the exact words that are going to be used. That's the whole point of having this conference. And so instead, what we have here is we've gone through all of the defense proposed instructions. And what does she say? Well, I'll give something like that, but it probably won't say this, or I'll give my own version of this or whatever. So what exactly is that, Bev? What's it going to say? Because I know, shocking revelation here. The words freaking matter. Details matter. They do. The words matter very, very much. We have no idea what words she intends to say to the jury, so we have no idea if it's objectionable or not. What a waste of time. This whole morning is I'll give something on that subject matter. Yeah, we know that because the form instructions, they all have form instructions on the subject matter. And on the one hand, you're saying, I'm going to tell the jury the SJC says I have to give these form instructions. And on the other one, you seem to be rejecting the form instructions that the defense is proposing you. I'll give something else. I got my own version that's a little more robust. I got my own version. So you're proposing to lie to the jury about the instructions that you're giving them? No wonder the standards in this court are such a freaking mess. What a waste of time. What a waste of time this instructions conference was. Ridiculous. And so what's going to happen? She's going to spend the day having her staff. She's not doing it herself. She's going to have her staff put together the draft instruction. She's going to circulate that to all the parties, probably before the end of the day. And then what's going to happen? We're supposed to walk right in tomorrow morning and go straight into arguments, go straight into the closings. So at what point are we going to review Judge Bev's wordsmithing and make our record of any objections or exceptions to the instructions as she's actually going to give them. Instead of just talking about topically what should be covered. We all know topically what should be covered. The form instructions tell us what the topics are. What matters is the words that you're going to use. And what's going to happen? If there's mistakes in these instructions, at what point are they caught, or at what point is that documented? Objections and exceptions, by the way, guys, objection. I object to what you are actually going to give, the actual language that you're going to give. I object to it. Exceptions. I take exception to you not giving the instruction the way I want you to give it to you. That's just the distinction between those two, objections and exceptions. Objections are to what is being given. Exceptions are to what is not being given. So, waste of a morning. We still have no idea really what instructions are going to be given or not. Let's recap this waste of a morning. We had the argument on, first off, the PowerPoint, Dr. Rentschler's PowerPoint, KKKK, it's not being admitted over the objection. I put a little star by this because I just want to, I kind of noticed a pattern yesterday, and I didn't mention it, but I've noticed it. I've noticed it several times. Have you noticed how repeatedly, especially over the last week, really in the defense case, she sent the defense team home with homework. They've had assignments that they're supposed to do. Go back and look at this. Go back, come back tomorrow and tell me this, that, or the other. Sends them home with homework. And she did that with Dr. Rentschler's PowerPoint. Go back, find the slides, go through the whole presentation, find the slides that you think have substantive evidence, come back to me with that. Now we walk in on the bench and she's just like not admitting it. So sent them off to do this busy work that apparently didn't matter at all, is a waste of time. She already knows what she's going to rule over objection. Because of the objection, I'm not going to admit it. That's not new. That's not new. You sent him off to do busy work. Why? Well, she hasn't done that to Hank, has she? And what's Hank been doing when he doesn't have busy work to do? He's filing all his motions. Couldn't help but notice that. A little bit of a pattern that's emerged, sending the defense team home with overnight homework that takes up their time and attention. They can't be filing motions. Not like Hank. And as it turns out, it's all pointless. It doesn't matter. They could have spent hours. It's a long PowerPoint. Going through that whole PowerPoint last night, and none of it matters. It's not admitted. So now at this point, the evidence is closed. We had the argument on the required finding of not guilty. Mr. Yannetti has just systematically gone through how the defense has demolished the Commonwealth's case. Lally, of course, gets up, denies it. No, there's no scintilla of evidence that there wasn't a dog there, except for all the people who said they didn't hear the dog, didn't see the dog. All except for that. Other than that, Lally. Defense is grossly overstating the strength of their case. The defense witnesses all conflict with each other. You have on the one hand, Dr. Russell talking about dog bites, and then you have Dr. Wolf and Dr. Rentschler talking about superficial abrasions. Oh, are you suggesting Dr. Rentschler should have been able to identify these abrasions as dog bites? Let me guess how that would have gone if they tried to do that. This is not a conflict, but this is advocacy. And then Lucky has the timing off with Dr. La Posada. You're gonna have to spell that out for me, because pretty sure what Dr. La Posada said was that if he died, he could lose heat at up to 4 degrees an hour. And if he was in something like an unheated garage, it would still be closer to that rate. So not seeing a problem with the timing here. But it doesn't matter. Lowley's argument is shit, but it doesn't matter because the standard is so low. All of the inferences from the evidence, you look at it in favor of the Commonwealth. You assume any conflicts, any credibility issues, etc., all get resolved in favor of the Commonwealth. So based on that, the motion is denied. It was always going to be, realistically, from the legal perspective, yeah, that is the right. That's the right ruling. It's just such a ridiculous prosecution to start with. So then we heard the defense is withdrawing their request for the missing witness instruction, withdrawing their request for lost or destroyed evidence. I'm intrigued by this, particularly with respect to Proctor, because it seems so related to the Bowden defense. I totally understand. Let's just go ahead and throw Brian Higgins and Brian Albert to the curb. We are walking away from pure third-party culprit. We are not going to assume that implicit burden of proof of convincing the jury that these guys did it. They affirmatively are the perpetrators. We are just going to focus on law enforcement didn't look at them at all. There's enough there to raise suspicion, but law enforcement couldn't be bothered. They were too focused on Karen, so they never went down this path. I can understand, let's throw them aside because of that. But Proctor seems like the one that you'd want that inference for, right? The reason why the Commonwealth didn't call Proctor is because Proctor's really bad for them. Proctor would damage their case. That's very consistent, really goes hand in hand with the Bowden. So I don't fully understand that decision, at least with respect to Proctor. I totally get it for Higgins and Albert, but either way, that's the decision that's been made. Strategic decision, not asking for any particularly adverse inference to be drawn from the Commonwealth not calling Proctor. Means they won't be able to argue that. That was one thing that was very clear from the rules surrounding this whole issue with the missing witnesses. If you want to make that argument at all, you have to get the instruction. So they're not going to make the argument. The reason the Commonwealth didn't call Proctor is because Proctor would demolish their case. Same thing with lost or destroyed evidence. I don't recall. I got to look at their proposed now because I don't remember if they had identified any particular evidence that was lost or destroyed. I think this was originally proposed in contemplation of like the Sallyport video. We do know there's the 43 minutes missing from the Sallyport video. That's about the only thing I can think of that's in evidence. Otherwise, maybe this was just going to relate to the phones, Brian Higgins and Brian Albert and their phones, but they were never ordered to turn them over. So I don't know if she would give them based on that. The language of the instruction itself was very brief. It didn't specify what they were talking about. So deleted text, deleted searches, I'm just just not sure what that contemplated in the first place because the instruction didn't spell it out. So withdrawing it, not asking for that either. It's a similar idea. If they have lost evidence, you should infer that that evidence would be bad for them. The 43 minutes in the Sallyport is the main one I can think of that seems like that is still kind of a live issue. But giving up that argument in that instruction. So then we go through the defenses proposed, and it was just a lot of you're proposing this instruction. I like mine better. I might give yours. I won't give you. What is evidence? I'm not going to give yours verbatim. Would you care to explain why? What's insufficient about the defendant's proposed? Do you even know if the defendant's proposed is the same as the form instruction? No reason. No reason for any of this. It's just bizarre. It really is just kind of bizarre. I'm not going to give yours. The defense does want an instruction about the defendant not testifying. That is appropriate. She hasn't testified. Sometimes you want it, sometimes you don't. You know, calling attention to it. But it does have some favorable language to the defendant. So that, let me find it in the defense proposed. It says, as you know, Ms. Reed did not testify at this trial. You may not hold that against her. Ms. Reed has an absolute right not to testify because, as I've explained, she is presumed to be innocent and does not have to do anything to convince you she is innocent. It does not matter why Ms. Reed did not testify. It is not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Ms. Reed is guilty beyond a reasonable doubt. The fact that Ms. Reed did not testify is not evidence, and you may not consider it or even discuss it in deciding this case. It's a pretty strong instruction. Your defense, defendant doesn't want to testify. You're going to give that. Jury's going to hold it. They do. They tend to hold it against the defendant anyway. But this instruction is at least intended to mitigate that. We get into Bowden. Lowley's like, they shouldn't be allowed. They shouldn't be allowed to argue Bowden because it's all just based on the defense's questions and not evidence that they presented. And again, it's ridiculous. They tried to present Michael Easter, Mr. Lowley. It was certainly not the defense's fault that they were not able to present affirmative evidence of investigative failures here. But no evidence about what they didn't do, just questions. Well, there are in fact answers to the questions as you go through a trial. This is the structure of a trial, that the attorneys ask questions and then the witnesses answer them. And then based on those answers, the jury gets to evaluate them. They get to draw inferences from them. They get to decide if they believe them or not. So the fact that there is testimony about the police investigation and the choices they made to do X, Y, and Z and how it unfolded, and Michael Proctor's text about no heat on the homeowner, and the fact they'd already called for the tow before they even left Canton on the way to Dighton, trying to say that you needed to look at John's body to confirm that this was a motor vehicle collision. Not sure how you managed to do that, Yuri, when all of the medical people couldn't do that. But that's his version. But you'd already decided to call a tow. The decision not to secure the crime scene, all the issues with the collection, like it's legion. Of course, there's a lot of evidence in here about police failing. And so Mr. Yannetti pointed a lot of that stuff out. Not securing the crime scene, the inadequate materials for collecting evidence, the absence of a chain of custody, the bias of the lead investigator. Also points out, yeah, we tried to bring in Mr. Easter. That wasn't our fault. Bev says, I'm allowing it and giving the instruction. Yeah, you better, because that would be a huge, huge error if you didn't do that. Defense has not requested third-party culprit. So they are not going to try to argue that Brian Albert, Brian Higgins specifically did in fact do this, or any way in which they did it. They are simply holding the line on, there was enough here to raise suspicion that the police should have investigated, and they did not do that. So Bev said, she reminded us her pretrial rulings, no third-party culprit argument could be made about Colin Albert. Not enough of a nexus had been shown with Colin. But she said that they could develop testimony regarding Brian Alberts and Brian Higgins, but they have not done that. So they cannot argue that these guys committed the crime, that they had a motive to commit the crime. That one's on the edge, isn't it? You can't argue they had a motive. Well, but that's what makes it an investigative failure that they didn't. The fact that it's so obvious that Higgins had a motive. Very obviously had a motive, and a very classic motive. Guys fighting over a girl. Drunk guys at that. Fighting over a girl. But Yannetti just clarifies they're they're just going with Bowden, straight Bowden, police investigation, didn't ask the questions. So I guess as long as they just say police didn't investigate whether Higgins had a motive, the police were aware of an apparent motive and didn't investigate. Not clear exactly where she's drawing that line, but Bev says you can get into the police were aware of this stuff and they failed to pursue it, failed to ask about it. Absence of a recording, meaning that the interviews were not recorded. That was, part of the issue with, investigative failure. We have to take the cops' word for it because they didn't bother recording a single one of these interviews, except apparently Lucky's a year and a half later after they'd lied about 34 Fairview not being plowed that night, which of course isn't in evidence, but we know from trial 1. So we ended up in this argument about whether it was a custodial interrogation. It was very hard to hear today. The sound was very bad. They're not standing at the microphone, so it's bad sound quality anyway. But there was something going on in there. It almost made it sound like you're inside an aquarium. It was like a bubble coming up or something. I don't know, it's very hard to describe, but I found it hard to hear at a lot of different points. So I couldn't tell exactly why we are transitioning from talking about recordings to talking about, is this a custodial interrogation of Karen at her parents' house? David Yannetti is making the argument that it is. It's not, guys. It's not. It's not. Custodial interrogation is a very specific legal standard for when Miranda rights are required to be given. And the custodial, it's only in a custodial interrogation when Miranda has to be read. And custodial means that the person being questioned has been subjected to the kind of restraint associated with a formal arrest. And so it doesn't mean specifically there has to be any kind of formality. You have to be like declared under arrest or anything like that. You don't even necessarily have to be in handcuffs, but they're going to look at all of the circumstances and evaluate, is this the functional equivalent of being under arrest? And the reality is here, she's unrestrained. She's sitting in her parents' living room. Could have refused. This was a voluntary interview, as the way that it's been described. She wasn't arrested at the end of it. It really wasn't going to be a good argument here that it was custodial. So, but they got to make it, I guess. I don't know. I probably wouldn't. I don't really see it there. But either way, no, she says it's not at issue. So then we start talking about the compromised mental state. And some language, I guess, in the proposed instructions about a compromised mental state. Yannetti is saying they're not arguing that applied to her interview at her parents' house. To me, seems to me like when you would expect to have a compromised mental state. She just got sectioned. She just got released from the hospital for a psychiatric hold, like 30 minutes, 30 minutes, like 3 hours before. I don't know, whatever, but it belongs in the humane treatment instruction. So the humane practice instruction basically just says the defendant's statements, before the jury is going to consider them, the jury has to find that they were knowingly, intelligently, and voluntarily made. And so any like bad treatment by police, any coercion, you can't beat her up to get the statement, that type of thing. It's just interesting for me to note this, that in Massachusetts, it's the jury that makes the decision about whether her statement is voluntary. You wouldn't have the jury making that decision over here in Washington. It's purely a legal question. The judge would decide that. But they give them an instruction that before they consider her statements, they have to determine that they were voluntarily made. So how she was treated and her condition at the time all go into that type of consideration. What's Bev's response to this argument? Well, I'll give some instruction on it. How unhelpful. What a waste of our time this morning. Some instruction she'll give. What would be cleaner and more efficient, just putting this out there, is that if you actually had your language that you were prepared to give ready, and the parties had already had a chance to review it and argue about it or not, then we would make our final ruling and we would be done. And we wouldn't have to worry about, you're going to give some other language that we're still going to have to come in and review and somehow make a record if we don't like it or not. A waste of our time. She'll give some instruction on it. On the jury view instruction, the defense wanted to repeat that rock, the painted Albert rock, wasn't present at the time. Bev says, I'm not going to repeat that. Direct versus indirect evidence, she'll give a shorter one. She'll cover these topics, not saying she'll give exactly what the defense has proposed. Why the hell not, Bev? What is your resistance? What is your resistance? Especially if you don't even have an objection from the Commonwealth. Okay, let me tell you how these instructions go in Washington. Washington, the judge doesn't prepare them. The prosecutor customarily prepares the full set of instructions, and the defense proposes any that they want different or in addition to what the prosecutor has proposed. And you just go through them. And so say we have an instruction on circumstantial evidence and the state's language is one way and the defense is proposing one with slightly different language. We have this argument to decide whose language are we going to use and why. And we make a final ruling and then we give that one. And it's very common to just go ahead and defer to what the defense is asking you for the same reason I just said. If the defense proposes an instruction and you give it, it's not going to come back on you on appeal because it's invited error. They proposed it. It's the safest thing to do for a judge is just give the instruction the defense wants. But she just like can't even do that. I'm not going to give this exact. She's going to literally like go in and tweak the words of the defense proposed just so she doesn't have to give it the way that they proposed it. And it's just wild, really wild. I'm not saying I'll give exactly this language, but I'll cover these general topics. Great to know that we've wasted our time this morning not knowing what you're going to actually say to the jury at the end of the day. The implicit bias, I'll give exactly what the Supreme Judicial Court said I have to give. Was there a case? Did she have a case? Was this just a judge case? Like a general case, somebody else? I don't know. I don't know that the Supreme Judicial Court has said she has to give any of these form instructions. Implicit bias instructions, I got mixed feelings about those. But then we turn to the Commonwealth instructions, and oddly enough, we're not taking issue with the wording of the Commonwealth's instructions. If they want a dangerous weapon instruction, she'll give it. She's going to give it. I'll give some instruction like that. I'll cover these topics. Not going to say exactly what words is. Commonwealth's dangerous weapon instruction, I'll give it. We had the defense joining in the Commonwealth's request for that instruction on the witness preparation. This is an instruction that says it's not improper to interview the witnesses before trial and to prepare their testimony. So that was obviously like every single defense witness. Often the very first thing that Mr. Brennan would get into. Did you ride over with the defense this morning? You had any conversations? Stuff like that. But, Mr. Jackson did it a lot too. How many times did you speak with the Commonwealth? So this is just telling the jury there's nothing inherently improper about doing that. She's giving a prior bad acts instruction about Aruba. Now, I had to remember, I had to go back and look. I want to see if I can find it because I don't think anybody requested a prior bad acts instruction. This was Bev on her own. I'm going to give this, and I'm going to give it based on Aruba. We didn't hear anything about Aruba because apparently she's saying it came in through Kaylee. We didn't hear Kaylee's testimony. So we don't know exactly what came in about that. What instruction on that are you going to give, Bev? What is your language going to be? That's what we needed to know to have a meaningful charge conference here in the court. We needed to know what your words are going to be, because how can we know if we object to your proposed instruction or not if we don't know what your instruction is? Mr. Yannetti said that the defense would object to a prior bad act instruction relating to Karen's text messages with Higgins. They're not going to concede that they don't even consider that a bad act. Hey, everybody's single, nobody's married. They're not even going to consider like the fact that she was texting with Higgins a bad act. They've really leaned into that, and I can have some respect for that. So don't know what Bev is going to give or not give on that. It will be a big surprise tomorrow. Hopefully, at least the defense team will have had an opportunity to review them sometime today before tomorrow. You know, she's going to be pissy as hell if she sends out her draft instructions tonight. There's all kinds of problems with them, and the defense shows up in court at 8:30 tomorrow as she's requested. And they have to put all these objections on the record. You know, she's going to be pissy as hell and blame them for that when it's her own damn fault for not being prepared for her own jury charge conference. So those were all of the general instructions. We then got into the specifics. The murder two, okay, they both sides now apparently want to take out all of the first two prongs of murder, okay, the intentional killing and the intent to cause grievous bodily harm to John. And they just want to proceed on a theory that Karen intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So they don't want to try to prove that Karen intended to kill him or even that she intended to hurt him, just that she did something really, really risky, likely to result in his death. And that is the, presumably the argument's going to be the putting the car in reverse and the rapid acceleration and going, 80 feet or whatever it was. I pointed this out because if they're not proceeding on these other prongs, yeah, you shouldn't have them in front of the jury at all. We got this whole doctrine in Washington about alternative means. The jury has to be unanimous on which version of the crime she committed, and so having these different versions that can be problematic. They're not disagreeing about taking it out, but she is. I'm not sure I can do that. Okay, so we're gonna have to do research on that. I'm concerned about it because it doesn't seem to add up to the language of the indictment. Let me just read the language of the indictment to you. On the second Thursday of June 2022, jurors for the Commonwealth of Massachusetts on their oath present that Karen Reed, on or about January 29th, 2022 at Canton in the county of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the second degree and not in the first degree. The indictment is for intentional murder. The indictment is not for grievous bodily harm, serious bodily harm. It's not the same theory. that got her indicted in the first place. So it's quite bizarre to me. It just really is quite bizarre to me that it's just so much deviation from the original indictment is allowed. It's indictments are, we don't do indictments in Washington, so I'm really not used to dealing with them. All I have is just kind of an intuitive reaction to the process and the significance of it. And it just, seems to me that if you present your one-sided, unopposed case theory evidence to the grand jury and get their agreement that this is the legal significance that it has, that you should be stuck with that. And if you're changing your evidence or you're changing your theory, the liability that you're trying to attach to that, the significance of it, I just don't see how we can kind of throw out that whole original grand jury process and have something completely different that the prosecutor has decided without any kind of ratification by we the people that make up the grand jury. Just seems quite peculiar to me, because it really does make this indictment. It's just a formality, and then it's not even binding. It's so strange to me, but I'll be the first to say I don't know what Massachusetts law on this is. But that's the first thing that stood out to me about, this is a discrepancy. The indictment very specifically intent to murder. That was what the grand jury, that's what you wanted the grand jury to find. That's what you asked them to find, and they did. But now you've abandoned that, but you're pursuing a theory of murder that the grand jury did not validate. I mean, I'm going to assume this is okay legally because nobody's screaming about it, but doesn't make a lot of sense to me from a fairness standpoint and then from a standpoint of just what the grand jury is supposed to do. The grand jury is supposed to be the check on the prosecutorial power. That if you want to pursue somebody criminally, you have to have the buy-in of regular members of the community. And I don't see how you achieve that when you go to the grand jury with one theory, get one crime, and then you go to trial and you present a different theory and you argue for a different crime. I just don't see it's fulfilling that function. So they're going to have to go do their homework yet again. See if they can find a case that says it's okay to not give these other options that nobody is relying on. And that's when she raised the issue that she might just tell the jurors that the Supreme Judicial Court has said these are model instructions that she has to give. If you just give the model instructions, Bev, then why don't you just say that initially? Why don't you just go ahead and put them together? Why do we have to like, if that's what the defense is proposing, which for the most part it is, then why do we have to be on, I'm not going to use your words. Which way is it? Unlike the first trial, it appears the Commonwealth is not looking for lesser included instructions on count 2. Again, very, very hard to hear, but that's what I took away from Mr. Lally a couple times, that the Commonwealth is not requesting lessers. The defense had their own proposed verdict form that we talked about. Before that, we had the whole issue with the thumb drive of Wolf's PowerPoint being handed up. It had to be redacted. And then, we're swapping labels and stuff like that. Very unclear how this evidence is being handled because it's a mess, because you shouldn't allow it into evidence unredacted if you're not going to let the jury see the unredacted one. Real simple. Unredacted, mark for identification. Don't let it in, but you've gone ahead and let it in, but now you're taking it back out. Very, very messy process. She's allowing 75 minutes for closing. 75. I'll allow an hour, 15 minutes. How generous. 2.5 hours. So based on her schedule, they start at 9 with the closings, done by 11:30, go to their early lunch for half an hour, 12, come back. She gives them the charge instruction. And then that'll probably take hour and a half to read all that. And then they'll go back and start their deliberations. So then we had this argument about the proposed verdict form of the defense, different from what was given last year. They had the whole problem with, only one not guilty option, but lots and lots and lots and lots of guilty options. So they've tried to make it easier. Commonwealth says they're not requesting any lessers. They think last year's verdict form is good enough. Bev, I don't think I'll use it, but I'll look at it. Don't think I'll give it. Don't know why. No reason. Just a knee jerk. Just the knee jerk. Commonwealth now clarifies we don't want the consciousness of guilt instruction, but we still want to be able to make consciousness of guilt arguments about Karen driving the SUV to Dighton and then some of the statements that she made in the interview. Defense objects to that. Driving to places that are known, where you admit you are, where you park the car openly in the driveway, and the defense says, sure, come on over. Doesn't really seem very consistent with consciousness of guilt. But Bev says she's going to allow the argument. So that's their response. They get to bring those things up in their own closing if they want to respond to that argument. She's not going to give the instruction, but it is a permissible inference. Then she wants to be sure you the defense, you sure you don't want it? Yeah, they're sure. Yeah, they're sure they don't want it. So then we had the argument from Mr. Alessi on the request for the curative instruction. Lally goes on the record first that they're just deferring to the court. Okay, he hates Brennan. He's not even going to get up there and have Brennan's back. We firmly oppose, vigorously contest this instruction, a false insinuation, disparaging Mr. Brennan. Lally hates him. Not even going to stand up for Mr. Brennan on that one. Just, we're going to defer to the court. We don't think you need to do anything else. Right to his face, even. Brennan's right there in court. And you're gonna not have his back like that. Telling you, nobody likes a turncoat. Nobody likes a turncoat. Nobody likes this guy. So then Mr. Alessi made the argument to try to describe as best as he could of what happened. The fact that the shirt was encased in the plexiglass, the prosecution had gone and put it behind the stand, but they didn't even know about it. And then confronted Dr. Wolf with it during his cross-examination, asking him, did you consider the existence of these other holes in the back? That led to the series of questions and answers. Defense believes the misconduct was intentional because it's completely undisputed that every hole in the back of the sweatshirt was caused by Maureen Hartnett, who is a witness for the Commonwealth. Part of the reason why they think it's intentional was because Wolf was starting to say, I know there was cutting to the sweatshirt, and then he was cut off by Hank. That's when Hank came up to the stand and said, let me show you this, or let me redirect you, or whatever. Cut him off. So according to Mr. Alessi, the request is quite modest given what happened. The actual instruction that the court gave was just one sentence saying that the holes were made by Hartnett. Didn't mention the date, anything like that, just during the course of her examination. Bev, this is what Bev is asking. Didn't I tell him the date? No, we don't believe you did, but we're not sure because we're all going from memory because we don't have a formal transcript. This is Bev telegraphing. I'll give it again, and I'll give him the date this time, but that whole falsely insinuated thing, not going to give that. No way is she going to give that. Absolutely no way is she going to give that. But the defense argument is that the instruction has to be related in its curative effect to what actually happened. And what actually happened is that we're talking about a significant topic, whether there was a collision. We're talking about a significant piece of evidence, the sweatshirt John was wearing at the time. And the whole effect of this was to leave the impression that Dr. Wolf had been incompetent and therefore his opinion should be discounted. And so that's the effect of that, is what has to be cured. He doesn't come out and say it, but that's why the defense is asking for that false insinuation language. Make it clear. Problem was on the Commonwealth. It was not on Dr. Wolf at all. So emphasizing they didn't cause this problem. The defense did not cause this problem. No, they did not. Don't know why the Commonwealth wouldn't support it. Well, we all know why. We know that the Commonwealth is allergic to its own accountability, and acknowledging that something was falsely insinuated by them, going to get their hackles up. Guys, they're the good guys. Don't you know that? They have the white hat because they sit at that table. So whatever they do is right and good. How can you possibly be calling them out as false like this? It's like doesn't even compute. They're the good guys. That's sarcasm if anybody's new here. So he just argues that the court's action, the curative instruction the court gave, it was not clear enough. Thinks they could be requesting a lot more than what they are asking. But the two issues the curative instruction needs to address are the fact that the holes were not there on January 29th when they came about. That was addressed by the court, but the impression that was potentially left on Mr. Wolf was not. So that's why they want that additional language. Now, Bev, I got to remind you, it wasn't objected to. The testimony wasn't objected to at the time that it came in. It wasn't objected to. Prosecutor knowingly presents false evidence to the jury. We're not going to worry about it because you didn't object to it. She's really putting that out there. Really putting that out there. Mr. Alessi points out we weren't shown what he was doing. It was behind the witness stand. He just took it straight to Dr. Wolf. We couldn't even see what happened. So we didn't have the ability to be able to respond at the time. Then we have Lally's response. What's Lally's response? Things can happen. Things can happen. Prosecutors can just lie at trial. It's just a thing. It's just a thing that can happen. He says it was recognized, it was acknowledged, it was accepted as a mistake. They offered a stipulation that was rejected by the defense. They wanted the curative instruction and they got it. There were many instances of conduct that didn't get an instruction like this. Really, Lally, do elaborate. Do elaborate. Tell us about Mr. Brennan's other lies. We know you hate him. We know you hate him. You can tell us. We'll give you our full attention. Go ahead and tell us, what are the other instances of conduct that warranted instruction? But in his view, the issue, it was immediately remedied. It doesn't need to be further addressed. And all we get from, I'll consider it. I'll consider it. It's been on your desk for a week, Bev. But thanks for wasting our time this morning with this charge conference. Then we get to the scheduling discussion. Jury is going to be asked to get in at 8:45. We'll hear the arguments. We'll take the early lunch, just a half an hour. She wants the jurors to be able to start deliberating. She's going to ask them if they can stay until 5 or 5:30. No objection to that by the defense. They need to get permission to be at his office 10 minutes away because last trial she said you have to be within 5 minutes. Bev says, well, but we'll have to talk about security issues. So they may not even be able to go wait in the relative comfort of Mr. Yanetti's office, where Mr. Yanetti can, do some of his other work and stuff like that. Might not be able to do that because of security issues, but, they'll have to talk about it. When? I don't know. Don't know when they'll talk about that. Nobody objects to the schedule. Council is to be there at 8:30 tomorrow. That's 5:30 my time. That means we are starting an extra early stream tomorrow, guys. 5:15 a.m. We will be here. Yikes. God, that's going to be an early morning. I didn't need to be in bed by like 7:30. It's crazy. So, waste of a day, waste of a day. Normally you would be walking out of this this conference and you would know what instructions were going to be given, and we don't. Par for the course. She's going to give some language and we have no idea if it's good language or not good language. And, yeah, if they even have prior notice, I can also see a scenario where the defense just walks in tomorrow morning and are handed what the court is going to read to the jury. And they don't even have a chance to read it over and think about if they're going to object to it or not. I can totally see that happening. And then they don't get to make their record. They don't get to preserve an error if they take issue with the language of some of the instructions. It's instruction by ambush. What a shit show. So, evidence labels being tossed around willy-nilly. We'll give some language, but we don't really know what. Things are going to be considered. What are you guys up to? What are you guys thinking? Roy Handy, Hank, I made a mistake. Hank's mom, so did I. Good one. Michael Muddragon. Hank's fabrication of hoodie evidence reminds me of the 1983 Air Supply classic, making glove out of nothing at all. Also, often, how do you see no rebuttal in a case? Hank giving no rebuttal has Elaine, I'm trying vibes. I mean, they did it in the first trial here. It's not really that unusual. It's not really that unusual. It's just it's so circumstantial because the rebuttal is the response to the defense case, and probably the majority of the time you don't even have a defense case. You go through a trial and their defense is going just on the prosecution's burden of proof, arguing they haven't met it. They don't put on any evidence at all. Very common. So they don't do anything. There's nothing to rebut. Or they just put on something really nominal. Don't need to rebut it. Sometimes it's just, say the defense calls their brother to come in and testify about their alibi, and Commonwealth gets them on cross-examination and the credibility problems and you never told anybody about this before, yada yada. You can handle that in that context. You don't have to call rebuttal for that. And so it's all very case dependent. I don't think it's that unusual to not have rebuttal. The reason why I think it's significant here is because we had anticipated it, and some of these things seemed like they were necessary. We didn't hear today anything about Dr. Kuhn, Terry Kuhn. I don't think she was a doctor. She's a professor. So probably maybe a PhD doctor, if I remember right. But the whole issue of the dog bite stuff not being in evidence, didn't hear anything about that today. Not asking for an instruction about it, nothing like that. It's unusual because we expected that, for foundational purposes, because you got to question Dr. Russell about it and then you just didn't follow through. That's a little bit weird. But then also, Welcher. Yeah, Welcher, you've been saying for months now. You've been saying for months now how they need the opportunity to go back in and respond to all these mistakes that ARCCA has been making, all these terrible things that they've done. You made a whole big stink about ARCCA has to do it fast so that you have time to get it, and that Welcher has time to do his own stuff and respond. And now you've just dropped all that. What this raises in my mind, really two big things. One, not ruling out that Hank was just lying all along about the intent of putting on a rebuttal case. Knew perfectly well he didn't ever intend to put on Terry Kuhn to get the dog DNA into evidence. Knew the whole time it was just to be able to talk to Dr. Russell about it, and we'll say whatever we need to do in the moment to make that happen, but no intention of following through on that. Definitely not going to rule that out. And same thing with Welcher. Knew the whole time we don't really have a response to ARCCA, not really going to. But if we can wield that as a sword to make it harder for the defense, so they have to rush, they have to get their stuff in, they can't complete everything they maybe need to do. We'll just get our advantage that way. Definitely one possibility that I see. Hank never intended to put on a rebuttal case. This has all just been bullshit. But the other way, I think, to see it, he did intend to put on a rebuttal case, but he got his ass handed to him and he quit. He just quit. He quit. He threw in the towel, got a little bit rocked and decided he had enough. I'll tell you, we've had a lot of conversations on here about Hank's future career, and is he hurting himself, and nobody's going to want to hire him after seeing how he behaves like this and so forth. And I've pushed back a little bit on that. Like, a lot of people want a shady lawyer. A lot of criminal defendants want a real shady, unethical lawyer who will be happy to lie and mislead and misrepresent and bully and insult, etc., on their behalf. But nobody wants a quitter. Nobody wants a quitter. Nobody wants a quitter. I think that might hurt him more than anything else, honestly. You got no dog in you. Nobody wants that. You want an attack dog, you need to have some dog in you. So don't see a really good alternative to these options. He never intended to put on a rebuttal case in the first place. Or he just quit because he got so thoroughly owned and decided he had enough. He didn't want the extra beating he was going to get finishing out this trial with your final witness, with Mr. Welcher. You knew it was going to be bad, and you just didn't have the heart for any more of it. Not a fighter, not a champ, this one. Hannah A. I had a ham and cheese sandwich for breakfast, rewatching Andrea's commentary of Dr. Laposada's testimony. Great way to start the day with some dopamine. A little croque monsieur. Is it croque monsieur or croque madame? I forget which one is which. Ham and cheese on a sandwich. Good for you. Breakfast of champions. Kiwi Kel, am I the only one thinking the pig DNA was from a pig ear treat? Nope, you are absolutely not. And it even came up in the first trial that dog treats, often made out of pork. They are crumbly and could easily transfer from canine teeth. They are. They're not only crumbly, but they're like gummy. Like once the dog has been chewing on it for a while and it's all gross. It's all covered with dog spit and stuff like that. It gets soft and it gets like slimy kind of. Ugh. The sweatshirt would work as a toothbrush. It bolsters the dog bite theory. I like that point. I hadn't really thought about that, but I think you are right because the material is absorbent. It would tend to pick up that pig DNA. Yeah, I could see that. But no, I think that's what's our options? It's from a dog treat or it's from Proctor, one way or the other. Pig DNA did not come from a tail light, I think is the bottom line. We don't have a good explanation for pig DNA coming from a tail light. Ron Steiner, do you think that Brennan would be able to indict Dr. Rentschler's ham sandwich? He definitely could. I mean, the indictment process is handmade for somebody like Brennan, who's more than happy to skew stuff and distort stuff and, again, present the one-sided version of things. Yeah, he could indict the ham sandwich. Don't know that he could go then and win it at trial, but I think he could get the indictment. The important part of the grand jury process here is that there's no defense witnesses. So the opportunities for him to reveal his driving asshole core, they're going to be minimized. He's just going to have friendlies and cooperatives that he's hand selected and he's cherry picked. He gets to go to Welcher, just him and Welcher get to tell the grand jury what they want. Yeah, he can indict the ham sandwich. Candy's Life, thank you for all of your hard work, Andrea. Well, thank you, Candy's Life. Thanks for being here. One more real early day tomorrow, and then, guys, and we're on verdict watch. I'm afraid to hope for a Friday verdict. I really am. I'm afraid to hope for it. I do want it, but I just, it's odds are against it, but wouldn't that be so nice? Samantha Teresa. I don't understand, however, the last jury unanimously claimed confusion on the instructions and Bev was given a hung jury. So why is she now claiming her instructions were fine, but now clarifying? I'm not sure, the big confusion had to do with that second verdict form. And we called this out in real time when it was happening during trial 1. This instruction, it's a problem. It's not systematic. It doesn't allow them to clearly work through and decide each charge before they move on to the next one. All it gives them the option to do is convict on any one of them, but acquit on all of them. And that's not their option. They can acquit as they work through the greater, the lesser, and so forth. It sounds like that's not going to be an issue here because the Commonwealth isn't requesting lessers this time. If the Commonwealth isn't requesting lessers this time, then it shouldn't be an issue. But she is very attached to her own language and her own way of doing things, isn't she? Even at the same time that she wants to tell the jury, the Supreme Judicial Court says, I have to give these instructions. You want to lie to the jury. Maybe that clarifies, maybe that will make it a little bit more clear why she doesn't have all of that grave concern about the Commonwealth doing the same thing. Pseudo RMRF, I didn't follow the first trial. How do current expectations feelings compare to this point in the last trial, mainly from FKR perspective? My personal perspective, after watching 2 trials, not remotely convinced that she did it. Not even by a long shot. So my perspective, most likely, actually innocent. That's not on the verdict form, however. The verdict form is just guilty or not guilty. Has the Commonwealth met its burden of proof? Absolutely not. So if there is a verdict in this case, what should it be? It should be not guilty. The odds of a guilty verdict seem very low, but you never know with the jury. You just never know. And because of that, the whole same, we don't know, and we don't know who's on the jury, and there's just you're taking a lot on faith when it comes to the actual jurors that end up in deliberation, that they did come in with an open mind, that they don't have the kind of biases that are like, I'm already going to be leaning toward guilt just because she's sitting there in a defense chair being accused of something. And they're going to have to, talk me out of that. You just don't know. You only need a couple people like that are like, well, I'm just inclined to think she's guilty anyway, to hang the jury. You just need a couple people who are like, well, but Turtle Boy really sucks. And she worked with him, and they've been so mean to these witnesses. You only need 1 or 2 of those people to get a hung jury. So I think it's a different case. Obviously, the first trial was focused a lot more on getting to what happened in the house, who was there, who did it. If Karen didn't do it, who did it? It was much more focused on that. And so because of that, the jury did hear a lot more about Brian Higgins, butt dials, everybody, everybody's story. But then the feedback that came out after the trial, particularly from juror Ronnie, was that none of that landed. The jury thought it was a distraction. Third-party culprit stuff was a distraction. So they've moved away from that this time. And, people are going to have mixed feelings about that, I think. If you're mostly focused on the facts and on getting to the truth and the whole idea that the trial is supposed to be an airing of what we know about what happened to John O'Keefe, that's part of the process of getting justice for John O'Keefe, then this trial fell short of the first trial, if that's kind of your perspective on what it's for. But if your perspective is on this is establishing whether or not the Commonwealth has overcome the burden of proof that Karen, or overcome the presumption of innocence that Karen didn't do it, and they have to prove she did, I think the defense is in a bit of a stronger position this time, because they are, focusing it as much more targeted, much more focused. And instead of implicitly saying, here's who did do it, so you jury need to decide who's right. Am I right, or is the Commonwealth right? It's just a little bit more of a unfavorable position to put yourself in with the defense strategy. This time, it's all the focus is on the Commonwealth in their case, and have they proved it? And so the focus is going to be on the holes in the Commonwealth's case, the questions they didn't ask, the options that they didn't evaluate. And I think that from a legal perspective, looking at it as a lawyer, I think it's a lot smarter. You don't take on that implicit burden of proving to the jury my own different theory of the case. And you also don't invite them to go down the rabbit hole of try to solve this. So one of the things I like about the Bowden is you can kind of use that to communicate to the jury why we can't solve it, because they didn't do what they needed to do to get the answers. How would we get the answers? The police didn't investigate it. How could we possibly expect to prove to you who did it when the police didn't bother to look at anybody but Karen? So I think they're in a much stronger position, just psychologically, like in terms of what the jury wants to do and the process that they're going to follow to try to do that. The first trial, I think, put them much more in a situation where the natural inclination is going to be, we're going to decide who's right, and then they can't, because you don't have enough evidence that Brian Albert did it or Brian Higgins did it or whatever. You don't know, because they didn't investigate. This trial, you're not giving them that invitation. You're keeping it squarely on, did the Commonwealth prove it or not? I think that was very smart. So from that perspective, I think they're in a stronger position this time. I do have hope. I think a conviction is very unlikely. Maybe on but if she's not even going to get a lesser for DUI, then I don't think she'll get a lesser, because the rest just depend on hitting John with the car. I think the best they could have hoped for here, conviction-wise, the conviction for DUI, operating under the influence. But it doesn't sound like they're even going to ask for that. If there is a verdict, acquittal seems likely to me, but no guarantee that there's going to be a verdict. So in that sense, similar to the last trial, but I do think the defense is a little bit better positioned this time. Rob Inson, I don't understand how she can keep their experts' report out. So many things in this trial make zero sense. So expert reports in general are not admissible. They are hearsay. They're out of court statements of the investigator. It's a writing. It's separate from the testimony that they're actually giving in court. The best evidence is their testimony in court. So it's just routine that the whole point of calling the expert is to testify to what you need from their report. To the extent there's anything in it that the defense needs, you know, the opportunity to get that in front of the jury is to elicit it in the testimony. It's nice to have the report if they want to go back and refer to it, because, you know, the exhibits are all they're going to have back there that they can look at and refresh themselves firsthand with that information. Testimony, they're stuck with their memories and their notes. But they can go back and look at the exhibits. That's why when Hank went ahead and put Matthew DeSogra's entire report into evidence, Mr. Alessi's like, no objection. It's absolutely, absolutely an own goal there. The jury is going to be sitting back there. Just imagine, you know, the jury is sitting back there and they're trying to sort out what sense can we make out of the phone data and the health data and the location and how all those things lined up and what exactly was the timeline of all this stuff. And some of them have notes and some of them don't have notes, and the notes maybe conflict in some places and it's all a big confusion. Some person says, I don't trust your notes anyway. Can't sort it out by the notes. Wouldn't it be nice if we all had something in common that we could share, that we could all put our eyes on to look at and answer all these questions, remind ourselves what the evidence was? Lo and behold, here's the defense's report. Here's the defense's take on everything and what it means. Just another own goal there by Mr. Brennan to provide them with that exhibit. So no, the reports are routinely not admissible. That in and of itself is not, that's not unusual. It's normal that the report wouldn't come in. Lottie bets on who the O'Keefes will choose to sit with them to mean mug the jury during closings. Don't know. Didn't they have the argument that I don't remember if we ever got a ruling on it. I remember last year. Now this year the jury doesn't know. They haven't been introduced to Brian Albert. They've seen Brian Higgins on the Sallyport video, but that's it. They don't know Colin. They know Jen. Last year it was Jen McCabe, Colin, and Brian Albert that were there in the courtroom for the closing. And some of the jurors suggested that was, you know, intimidating, didn't like it. But they knew who all those people were last year. This year, if Colin Albert showed up, they wouldn't have any reason to know who he was. Same thing with Brian Albert. They wouldn't have any reason to recognize him. That's part of why I think the effect of having them in court would be less. So if you're trying to send a signal to the jury about where your loyalties are, it doesn't help you to bring those people in that they don't recognize. So I think you know, Jen McCabe is on the short list. Carrie Roberts, go ahead and get Carrie in. You know, why not? Don't know about any other witnesses. Maybe who was that? Who is the guy? Was it Whitley? Whitley, who was like the old neighbor of Carrie or something like that. Maybe Katie McLaughlin. You know, I don't know. Seems unlikely, but not impossible. But I'd say Jen McCabe and Carrie Roberts maybe on the short list. What do you guys think? What do you think? Who are they gonna bring in to Grant? No, please no. I don't recall that Bev ever ruled on do the witnesses get to come back in for closing. I don't think she ever ruled on it. So we'll see. That'll be intriguing, won't it? Any thoughts on the unsolved murder of federal prosecutor Thomas Wales in Seattle in 2001? I do not have any thoughts about that. I don't actually know much about it. It's you know, I know the name. Don't really know anything about the investigation or anything like that. Maybe I'll look it up. I'll see. People have been asking me a lot, you know, what are you going to do when this trial's over? Well, you know, as always, guys, if you're new to the channel, I'm going to disappear for a while. That's what happens. That's what happens. You know, we put in a lot of hours here doing the gavel to gavel coverage. A lot of life being put to the side, you know, to do this. So I am going to disappear for a while. Don't know how long, but probably won't be making a lot of content while I go ahead and get some life stuff taken care of again. Oh, you should see my apricot trees. They're a disaster. They're a disaster. I'm so behind. I couldn't ever finish my thinning. I got summer pruning I need to do. So much stuff. Apples. I haven't bagged my apples yet. They're probably out there getting moth eaten as we speak. Gonna need to do that. And enjoy some summer. You know, it's important to do those things. So, but you know, I always have ideas about things to do, little small things, maybe smaller project kinds of things that don't necessarily take up the time and attention of you know, following a full 2-month trial, every day of it from beginning to end. So I'll put Thomas Wales on my list and see if that's something that might be interesting to follow up on. So thanks for bringing that up. Thanks, love your laugh. Well, thank you. Appreciate you being here. Appreciate you having the suggestions. Aaron White, a classic example of let's have a meeting to prepare for another meeting. Yes, let's have a meeting to achieve nothing. Let's have a meeting to talk about why this should have been an email and then we should have deferred the meeting until we were ready for the meeting. Ugh. Yes, waste of time and no reason closing arguments could not have happened today. I suspect if they did the closings today, it would have been closings, and it's not clear she would have had enough time to also give the instructions themselves. If they had been on the ball and done things ahead of time in a timely fashion, not continued to waste time and do things last minute, we would have walked in this morning. We would have had the the final draft of the instructions. The judge would have put them together. Parties would have already had them. Parties would already know, I'm going to object to this language. We're going to haggle over these other ones. We're going to talk about the ones I want that you haven't given. We're going to talk about the ones that you're giving that I don't want. And all the final decisions are going to be made. And then those instructions are finalized. And then we are ready to go. In normal courtrooms across the country, that's what happens. That's the process. And so that would have happened this morning. Would it have taken significantly longer than what we just did? I don't think so. I don't see why. We've been out for probably almost an hour, and we're still only like 3 hours in, not even. So would have had time to finalize the instructions. Would have had time. We would have had, you know, if they started right now, 12:30 in the afternoon over there on the East Coast. 2.5 hours for the arguments, right? So that gets us to 3 o'clock. You got an hour to read your instructions, hour and a half, whatever. Then the jury goes home. That's why we got to get them to deliberation. Ideally, it's, you know, she's not wrong. That's preferred. Don't do it all and then have a gap before they can even get started. But, you know, it happens sometimes. The schedule is flexible. It just depends on the needs of the task. Sometimes you don't get to do things exactly the way you want to, but you have priorities. Do you get the case done, or do you waste all this time, send the jury home for another day? You know, can't go back to work, can't go back to their normal lives, but so much hypocrisy over the wasting of the jury's time. isn't there? What a waste of their time taking today off was. A to Z, how in the world can you prepare a closing not even knowing what your instructions are? This is such a good observation because it's one of the, especially for the defense, but I mean, really both sides. It's one of the classic approaches to your closing argument is drawing the jury's attention to the instructions that you want them to pay attention on and explaining to them what they mean, how they should interpret them, how they should apply them given the evidence in your case. So you don't even know what instruction she's going to give. All you know, she's going to cover the topic. It's not particularly helpful, is it? Yeah, WTF indeed. Summertime. Is Bev speaking on increased security because she thinks or knows Karen Reed will be found guilty? It's so horrible the way she runs her courtroom. I didn't get that. I didn't get that. I would expect that, you know, she's anticipating that regardless of what the verdict is, there are going to be strong feelings about it. Either way. And so if there's strong feelings in reaction to a verdict, there's always going to be a risk that somebody is going to act on their feelings. Who is that? What's the name of that guy? The Boston cop who got booted out of the courtroom last time because he like body checked Karen in the hall or something like that. You know, what was that guy's name? He's been back in, I think, in this trial. He's been back in. His wife has been in the courtroom. Can't remember the guy's name off the top of my head. You would expect things like that. You know, there's at least a higher risk. Dougal, thank you. Thank you, Bridget. Thank you, Melanie. Carl Dougal. Yep, exactly. Or Dugan. Dougal. I don't know. Something like that. So that's what we're concerned about. That's what she's concerned about, I think. And I don't know. I don't know that that's particular to any side. But yeah, her running the courtroom, it's just not impressed. Not impressed at all. Matthew Madu. No rebuttal means the defense can't counter the dog DNA question. Weren't there other things they were told could be cured during the Commonwealth's rebuttal? I think that was the main thing. I can't remember anything else off the top of my head that was going to be out there for rebuttal. We know that, of course, there was the whole issue with, well, if La Posada doesn't say anything about dog bites, we won't call Crosby. Now, of course, I wonder you weren't going to call Crosby at all anyway. Now I got to wonder, you were never going to do that anyway. All of that was just leverage. All of it was just leverage to get Judge Bev to give you the rulings that you wanted so that the trial would be done sooner. And, you know. Everybody can go back to their summer business, whatever that may be, sooner rather than later. Can't think of anything else specifically that came up that they were supposed to address or cure in rebuttal. It was really the aperture. You know, aperture has to have time to respond, and so ARCCA has to jump through all these hoops and stuff like that to give aperture the time that they need to be able to react to all the terrible mistakes that ARCCA made and the negligence and the sloppiness and yada yada, all those types of things. But otherwise, I think that I can't think of anything else off the top of my head that was supposed to be cured. That was mainly the dog DNA issue, the Kuhn. But they didn't even say that on the record, too. It's important to remember that. They never said that on the record, that you're going to have to bring Kuhn in, because they had that whole conversation at sidebar. They never said you're going to have to bring her in. in order to ask Dr. Russell these questions? I don't think we heard that. It's just kind of implied because you got a confrontation issue. You should know that. But it wasn't invoked. Maybe it doesn't matter. Pseudo RMRF. Now you've watched both sides present their cases. Thought it would be funny if you attempt to rank Bev's favorite to least favorite defense attorneys. Defense attorneys. Ms. Little is definitely her favorite. Ms. Little is definitely her favorite. Even though she treats her like a paralegal, Ms. Little, go find me this document, go find this reference in the record, whatever. She treats her like a paralegal, but she is also most respectful to her, just in her demeanor and in her presentation. I think she respects that Ms. Little is the library. She's the repository of knowledge about the case. She does know where everything is. She's the one that knows the stuff. I think she does get a little bit of trust from the judge because of that. Ms. Little's the favorite. I think we're really close between Mr. Alessi and Mr. Yannetti for next in line. She doesn't like either of them, but like which one does she dislike more? I think it's hard to say. She doesn't like Mr. Yannetti because it was her initial reaction. You know, he's the outsider. He's not a local guy. He's involved in the press stuff, you know, the statements. He's made his own statements to the press. She doesn't like that. She made that comment to him in the first trial when he's making his argument about how, you know, address your argument to me, you're not trying to convince all of us watching. We're not the audience. So a lot of implication there that he's playing to the cameras. Mr. Alessi, I think she just doesn't like because he's a very good lawyer. He's smarter than she is. So she doesn't like him because he's dangerous. He can outmaneuver her. She really wants to catch him in something. You know, she really wanted to tie him in with the whole candor issue. Couldn't quite do that. But then just a couple days ago when they were talking about Welcher's slides and what was in, and she was so enthusiastic about, you know, Ms. Little and Mr. Alessi, contrary to what you represented. These were black. Mr. Alessi didn't even say anything. He was just sitting there nodding in agreement that certain of Welcher's PowerPoint slides had gone to the jury, but she just had to draw him into it. She wants to dirty him up. She doesn't like him because he's a very good lawyer. And then Mr. Jackson, she hates, you know, totally hates him. Just gets huffing and puffing, does not like him at all. Why? You know, hard to say, but probably because he's Mr. Yannetti with the media side of the strategy, but you know, turned up to 11. He's the media guy. She hates that part of it. She doesn't like them doing that. So to the extent he's kind of in charge of that, she doesn't like that. That's my ranking. Interested in what you guys think. What do you think? I got Little at the top, Jackson at the bottom, and Alessi and Yannetti kind of tied for middle. Optopuppet. I am confused and shouldn't be. Are there lesser included charges on charge 2 or not? We're all confused. Lally said they're not requesting any, so it sounds like no. It sounds like no. Bev was all confusing because she's saying, well, there's lesser includeds in the indictment. No, Judge, there are not lesser includeds in the indictment. Here is the indictment. The indictment, first one, we already went through it. Murder in the second degree with intent to murder such person, an intentional murder theory in the first indictment. Second indictment, Karen Reed did operate a motor vehicle on a way as defined by state law, or in a place to which the public has a right of access, or upon a way she drove on a road. With a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person, to wit, John O'Keefe. This is the manslaughter by OUI charge. And then the third indictment, Karen Reed did operate a motor vehicle upon a way or in a place to which the public has a right of access, again, on a way, and without stopping and making known her name, residence, and the registration number of her motor vehicle, did go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person. This is hit and run. This is leaving the scene of the crime, I think is leaving the scene of an accident is how Massachusetts describes it. It's hit and run. Those are the three indictments. Those are not lesser. Those are separate. Those are separate and independent. So I don't know where she was getting that there's lessers. Doesn't seem like the defense is requesting lessers, right? The defense is not going to go in and be like, look, jury, she's not guilty of manslaughter, but go ahead and give her the DUI. I don't think they're going to do that. They do have the right to. Both parties have the right in Massachusetts to ask for lesser included instructions. Lally made it clear that they are not. I seriously doubt the defense is, but I guess maybe that's possible. I'm still confused too. Not clear at all. You know, if somebody had done their job and had the instructions and the verdict form and so forth ready to go before we have this charge conference, so that this charge conference would be meaningful, we would know, but we don't. So it will be a surprise, I guess, when we show up tomorrow and find out. Time and tide for nay man bide. What's the bins judge cited for one instruction? Yeah, I don't know the name of it. But a case that she cited, what was that one about? I don't think it was past the implicit bias. Don't think it was the verdict. Don't think it was consciousness of guilt. Might have been consciousness of guilt. Was it that? Yeah, I don't remember. I didn't write it down because I didn't know. You know, I can hardly hear. I don't know how it's spelled. I don't know what the case is. So I didn't write it down. But I did catch that she said that. If somebody finds the case, I'm sure it will make it clear. But I didn't catch it myself. 40 Doherty. Why would they not look for lessers on count 2 if that's where jury 1 was hung? P.S. That color looks great on you. Thanks for all your coverage. Well, thank you. I love my sort of sage green. I like a good sage green. Like a lot of different colors. It's very common strategy on the defense case to go all or nothing. Go all or nothing. If you don't think that they've proved it, you don't give the jury a compromised position. You hold them to. You got to find the Commonwealth has met its burden of proof. If not, you go home. That's the job here. And just because you think maybe Karen did something wrong or Karen wasn't perfect or you don't like her, that's not what you're here to decide. You're here to decide these specific charges are what the Commonwealth decided to bring. And your question is, have they proved it? It's consistent with their theory so far. Very, very focused on the Commonwealth's burden of proof. So why give them a gift? Why give them an out? Go ahead and convict her for DUI. If the Commonwealth doesn't want to try for that, then why would you? No, I don't think you vindicate that. Especially given their whole theory here, there was no collision. Everything that she is charged with requires a collision. Don't give them a non-collision out. Make the Commonwealth request that. But they're not even doing that. They don't even want the the compromised DUI. So it's strategy. Very common to do that. Go all or nothing. Tina Lewis, be interesting to hear from the defense team and their perspective of all this mess when everything is done. Oh, I completely agree. I completely agree. I wonder who's going to get the interview. Somebody's going to get the interview. 60 Minutes, so somebody. I don't know. I don't know who it'll be. But I would like to see that too. Karen and the team and their thoughts about all this stuff. Raina, this is why Bev ingratiates herself so heavily to the jurors. It's effective to get them to like and trust her. Personal interest in the outcome. It's not really, again, that out of the norm for the judges to be like this with the jury, to be a little, suck up to them and stuff like that. Now, I'm used to it in our jurisdiction where the judges are elected. So the jurors are not only deciding the case, they're also deciding if you keep your job in, I think it's 6 years, maybe 4. I forget off the top of my head what the term is for a superior court judge. I think it's 6. So they don't have that motivation over here in Massachusetts. But nevertheless, this is your public. These are special people to you. These are, you don't have jury trials every day. These are not the people you normally are dealing with. They're special people. So in and of itself, the fact that she's all, welcome back, jurors. In and of itself, like that doesn't surprise me all that much. But I absolutely think you're right. She does want to be liked by the jury. She does want to be trusted by the jury. And I don't know if it's because she's, necessarily thinking that's going to translate into they'll give her the outcome that she wants. But I think it does have those downstream effects of if the jury likes me and trusts me, they're not going to ask too many questions about why do I appear to be treating these sides so differently. They may not even notice, but even if they do notice, if they trust me, they'll assume it's their fault. They'll assume the Commonwealth is doing everything right. That's why I'm allowing what they're trying to do. And the defense is doing everything wrong. That's why I'm sustaining everything. She wants them to take that on faith, that her rulings on that are correct and not to be questioned in any sort of way. But the jury's going to see for itself, wow, this guy has been real rude and he's really hounded these people and he's asked the same thing over and over and over again. And the defense is just over here trying to get answers to questions, trying to get information out. And the Commonwealth doesn't want us to know those things and we're not being allowed to hear it, but they're being perfectly polite about it. Like the jury is going to notice a lot of this stuff anyway. So yeah, she I think leans on that sucking up to the jury to just try to make sure we land on the side of, well, judge is in charge. She seems nice enough. Guess she's probably got it right. Guess we should just follow that instruction, listen to that instruction about not really worrying about the reason for any of these rulings and stuff like that. Texas Sister 2. We worried about the defense not calling Proctor Higgy, but they had it right. So we should trust them dropping third party and missing witnesses. I definitely think at this point, we've had a lot of time to sit with these decisions that have been made, and it makes us nerve-wracking. There's stuff on the table that got left on the table. I know, but I very much come around to the perspective that it's not central to their theory of the case. And that's what I said from the very beginning. It's the best way to construct a case. You've got your theory and you keep it focused on that. You don't get distracted with all the possible things that you could go down. Your only question is, does this advance my theory of the case or does it not? And so you do make those decisions that just every fact, just because a fact is beneficial to your client doesn't mean it needs to come in, because if it doesn't advance your theory of the case, it's not getting you anywhere. And it may in fact turn out to just be a distraction. It may turn out to have, some effect on the jury that you didn't want and didn't anticipate. So definitely keeping it focused on the Bowden, on the Commonwealth's burden of proof. I think I very much support that refinement. I think that's a good idea. Proctor is harder, because Proctor is he is central. He is central to the Bowden issue, but I like him. I like him being a ghost. I like him being a boogeyman. I like him not being humanized. I like him just existing in the juror's imagination. That's good for the defense, I think. Yeah, they left some stuff on the table, like the gift to Courtney Proctor, and those texts, and then wish she'd kill herself. But they heard an awful lot, guys. I think they probably heard what they needed to hear. Not asking for a missing witness instruction. That I'm just not sure I get. I don't know. I guess I'm not sure why you didn't. I'd love to hear their thought process about that. Why not push for that if you can get the inference? No, they're probably not going to get it anyway. But why not push for it? I'm very interested in their logic on that, because that is still perfectly consistent with the Bowden and with the strategy that they've pursued, especially considering the focus on the Commonwealth's burden of proof. They have the burden of proof. They wouldn't even call their lead investigator. You should be asking yourself why. What does he know that they don't want you to hear about? They're taking that off the table. I'm not sure why. Maybe they just decided they don't need it. I would love to know the thought process about that one. I'm not going to say they're wrong at all. They know so much more about this case than I do. They know more about their theory than I do. Definitely not going to say they're wrong. But just the logic of letting go that one is not really the same as the logic of not calling him in the first place, letting go of Brian Albert and Brian Higgins and all that. It's just a little bit of a different logic. So I'm curious about it. I would love to know. Not quite sure what I think about that. Prime Finder, any decision read bold font on the third charge? No. The argument was that both sides agree that rather than having the third part bold, we'd rather just not have the first two prongs talked about at all in the instruction. Just take it all out of the instruction. Bev has had all of this concern about, well, this should be simpler, or, I don't want to give this one. It says all this stuff that's extraneous, but now you want to give them language that neither party is requesting on the to convict instruction, like one of the most, important instructions out there. You want to fluff that up with stuff that the jury isn't going to be asked to pay attention to, but it's just going to be in there. That's the one she's got pushback on. So she doesn't know. She doesn't know yet what she's going to do. She doesn't know. She wants a case by the end of the day that says she's allowed to not instruct on the prongs that nobody is arguing. Trying to think of how this would be error when it's joined in by both sides. Even if it is error, it's invited. Defense can't argue it. It's invited error. I don't know. So we don't have an answer yet. We'll find out. We'll get a surprise tomorrow. Michelle J. Sorry if this has been answered, but AJ hammered Proctor and Higgy in his opening statements. What could he possibly say in closing to circle back to that after promising they'd hear all about them? I don't know. Because you don't get to comment on what's not in evidence. You don't get to comment on what's not in evidence. You can say things like, things change over the course of the trial, and Sometimes stuff we think is going to come in front of you doesn't for some reason or another, but what you did hear is enough for you to reach these conclusions. You could try to touch on it a little bit like that. Or you just, don't address it. Just let it go. I don't know. I think most of what he had addressed about Proctor in opening did in fact come in, and the most important things. He's a Boston cop too. No shit on the homeowner. He said that a few times. That got in, so that was the important point. The butt dials is really the main thing that jumps out to me that didn't come in. The Brian Higgins and Brian Albert butt dials, the whole just sus activity that the whole crew was engaged in early morning of January 29th. So I don't know. I don't know if the jury's going to remember that. I don't know if he's going to try to brush it off as well. Sometimes things change between the time you give your opening and the time you come back and talk in closing, and you don't always get to present everything that you anticipate. But what you did here is sufficient for you to conclude that the Commonwealth hasn't met its burden of proof. Something like that. My personal view is probably, well, it might be and it depends. Generally it's probably better to address it than let it slide, but just not. You don't put a lot of weight on it. You don't want to suggest to the jury it's a bad thing that I never presented this to you after I mentioned it in opening, because if that hasn't crossed their mind, don't suggest it to them. Possibly you wait and see what Brennan says is in his opening first, right? He gets to go first. Does he call it out? Does he make it an issue? If he makes it an issue, more likely you need to respond to it in some way. Doesn't mean even if you don't, though, that he can't come back and rebuttal. Be like they never said anything about why, they told you you'd hear this from Brian Higgins and you never did. You never did hear that. It's a strategic decision that they have to make. It's the position that they're in. And I have to think that they made their decisions about not calling Brian Albert, Brian Higgins, etc., already knowing that. They know what they said in opening. So they have that in mind. I have to think that they have they've already, factored that in, what the possible effect on their closing would need to be as a result of that decision. So we'll see what they come up with. Cyornis, Commonwealth jury instructions. Innocence proves nothing. The plea of not guilty is guilty of wasting our time. They would love that instruction, wouldn't they? They would love that instruction. They would love an instruction on this trial. Thank you for enduring the formality that this trial has been. Please go back and do your duty and write guilty on all of these forms that we're going to hand you. They would love an instruction like that. Dr. Rentschler's ham sandwich, kimchi. Kimchi? A kimchi ham sandwich? No, don't indict me. The kimchi maybe would be your saving grace. It's not for everybody. I love kimchi. But I recognize it's not for everybody. Bally, please play devil's advocate. What will be Brennan's strongest parts in summation? Polymarket chance of guilty verdict now 30% up from 16% yesterday. Interesting. I wonder why. Wonder what that's based on. The not further damaging yourself in rebuttal. I don't know what that would be. There's been no significant change since yesterday. Strongest parts in his summation are going to be, he's going to lean on, what Karen has said, Karen's admissions. He's going to treat I hit him as gospel and pretend like there aren't questions about whether she actually, ever said that or not. He's going to disregard, not mention issues with the credibility of the people that report that. So he's going to lean very, very heavily on Karen's admissions. He's going to lean if I'm Brennan and I'm making this closing, I'm going to lean on, it would have to be a remarkable coincidence. Just a remarkable coincidence that she happened to break her taillight that morning, that she happened to break into John's car. She happened to back into John's car and have this explanation for breaking her taillight when there's all this taillight all over the yard, all this taillight that's later recovered from the scene. There's no, innocent explanation for how it all ended up. There has to be quite a coincidence that, she just happened to leave taillight all over 34 Fairview Yard. And then the next morning when it turns out, John is dead, maybe it's worse than she anticipated. That now she's gone in and backed into John's car and broken her taillight that way. Massive coincidence that all, the ring camera footage, the missing ring camera footage. Coincidence that the part where she's pointing out the broken taillight, she that's missing. That's a coincidence you have to take. Coincidence that she's saying from the very beginning, John is dead and her taillight's broken and she thinks she did it. Pretty big coincidence that all of those things happened if she didn't do it. If there wasn't in fact a collision. Pretty big coincidence that there's all this data on her car that suggests she did this rapid backing maneuver that shows she did it right outside 34 Fairview, shows she did it right at the time that John's phone stopped moving. Big coincidence. That's really what I'm going to focus on, I think, if I'm the Commonwealth. They aren't coincidence, it's because they're circumstantial. It's not a coincidence. At a certain point, coincidences stop becoming coincidences, and they're circumstantial evidence. You'd have to accept that these are a lot of coincidences to think these are not consistent with her guilt. You probably actually can't say that as a prosecutor. You don't get to say what the jury has to find other than not guilty. I'm not a prosecutor, so I'm not used to having to follow the prosecutor's rules of argument. But that's generally what I'm going to focus on. I think it's quite a coincidence that she's running around telling everybody she did it that morning, and her taillight's all over the yard, and so forth. And the data's in her vehicle, and it's all at the time John's phone stopped moving. Awfully big coincidence if she didn't actually do it. 4 knots to nowhere. The ham sandwich yelled, "I hit him, I hit him, I hit him." But was it 2 times or 3 times or 4 times? Did it have a question mark at the end? Ham sandwich yelled out in consciousness of guilt. Deanna, does anyone else think that Adam Lally is smiling inside at Hank's shortcomings? We've seen it. We have seen Mr. Lally absolutely come to life in the few pieces of this trial, the unimportant things that he was allowed to handle when he got to question. It really was amazing. It's like watching a new man. He looks healthier. He looks like he's been on some kind of a health kick of some kind. Maybe he's not, smoking as much. I don't know. Maybe he's working out. Maybe his diet's better. I don't know. He looks better than he did last year. He speaks with an energy that he didn't have last year, a confidence in his questions. His questions are constructed better. I do. I feel like watching Hank flail has brought new life into Lally. Like he realizes, not only do you realize it's not just him, but I'm telling you, I get a real strong feeling. I feel like that was substantiated a little bit today. Lally hates this guy's guts. Lally hates him. Not even going to stand up for him on, misconduct. We're just going to defer to the court. He's going to strenuously, argue, object to Bowden. You're going to strenuously, with your whole chest, object to Bowden, which, like, there's not going to be any question they're going to get that in this case. It's very clearly applicable. You're gonna go all in on that, but you're not going to defend that guy sitting over there against an instruction that talks about him falsely insinuating facts. You're just going to defer to the court on that one. I find that quite remarkable. I think he hates Brennan's guts. And you got to notice too, we've talked about the misconduct. Since we're talking about the misconduct, the holes, we talked about that as Napui error. Okay, the prosecution does not get to rely on false evidence. Lally didn't correct it either, did he? McLaughlin didn't correct it either, did she? Well, Lally's got plenty of his own skeletons in the closet of this case, but he's skated through it so far. You gotta wonder if he's like sitting there thinking Brennan's gonna blow it. He's gonna blow it for all of them. Just take the shenanigans too far. I don't know. Don't know what's going on in the background, but no, you are not alone, Deanna. Hank has come to, or Adam Lally has come to life like we hadn't seen him before. Send it. Was the last image of the house displayed with the garage redacted? Yes, it was. Indeed, it was. For some reason, too prejudicial to admit that defense photo that the investigator took showing the garage doors. Too prejudicial to show that. Absolutely no idea why that would be the case. The whole point was that they're arguing, okay, you have steps and you have measurements and stuff like that. We have John's step data. And so can that add up to him being inside the house or in the garage? Those garage doors could be open. That can be a way to get in through the garage. I'm not sure why we get to talk about the side door to the garage, but not the actual, garage doors. You can go in the garage through both of them. Did they not measure to the garage door or something? So I don't know. It's not like it's a mystery that the house has garage doors because the Commonwealth's own picture has them up there. Ugh, I don't understand it at all. But yes, you are correct. It was. The garage was redacted from that photo. Google Maps Street View has garage blurred from west to east angles, aka the step into the garage. Interesting. Gotta wonder about that, huh? Why would Google be blurring the step into the garage? Did show that step, right? That was where they were trying to get with Dr. La Posada. We heard just enough to know what the defense is getting at. And you see the step outside that garage door, you have to step up to the level of the door. You're going to have a corresponding step down on the other side. If it's, I don't know, concrete and pebbly, then that could match the raised surface that Dr. La Posada was saying would have been necessary to cause that injury. And Google has it blurred. Intriguing. Emotional Lemonade. Thank you for 6 weeks of early mornings, legal insight, intellectual side quests into the deep, dark alleyways of case law, and equally intellectual your mom jokes. You're a rare gem, ma'am. Well, thank you. Thank you for that. I do appreciate it. This is a little bit of a long trial, but God, Koberger is going to be Koberger is going to be a whole next level. Koberger is going to be months long. But I've been happy to do it. The East Coast schedule is a little trying for a not naturally inclined morning person, but we adjust. You get used to it, and I just appreciate that folks are interested in that kind of context. Understanding things from the legal perspective, having what I hope is a little bit of a more in-depth understanding of what's going on. And so that's not just for this case, that you can understand maybe a little bit more about the process and in the rules and how it's all supposed to work and stuff like that. And it's just all part of being good watchers of our courts. Guys, there are courts. They belong to us. What's done in there is done in our name. So important to watch what's going on in the courts, not just these high profile cases. The massive volume of cases that go through these courts every day that we never hear about. But these issues we're hearing about in Karen Reed's case, these problems, these shenanigans, they're not unique to her. Guys, massive volume of this stuff going through the courts. So that's really my goal, is to just help people be more aware of what's going on, how it's supposed to be, and empower us to look at what is happening in our courts and be able to judge if it's working the way it should be, working the way it's supposed to or not. So thanks for being here with me to do that, for having the interest in it. Wouldn't be doing it if folks weren't interested in hearing it. So thank you very much for that. In Wings. Hey, Andrea, what do you think about ARCCA not recreating Karen hitting John O'Keefe car in the driveway to prove broken taillight? I think they probably ran out of time. That would be my guess. Remember they had to do it over the weekend, and even from the very first time they knew ARCCA was going to be able to testify at all. It was like, what do they have, like 10 days or something to get it in? It wasn't very long. So they had to prioritize what they could do. This is a completely different setup, for testing and stuff like that. That's my main guess. It's just they didn't have time to do both things, so they had to pick the one that was important, and the one that was most important was the no collision between John and the car. Possible it's not enough force. We know it wasn't enough to produce the force in for what you saw in the Sally port. So if it didn't produce that much damage, maybe it's just murky, muddies the water a little bit. I don't know. Could be that they decided it wasn't necessary because when they did that first initial testing for the FBI, for the independent agency, they already evaluate the force needed to crack her taillight? Maybe they just, I guess they didn't. Now that I think about it, they didn't address, they didn't address this specifically. But maybe they just think there's enough in what they already did do to give the jury the sense of, it's not necessarily that hard to break the outer lens. They were able to do that with, relatively lower speed and minimal contact with an arm and stuff like that. And arm, obviously, relative to another car. Not a big mass giving you resistance back. I don't know, but my big guess is just they didn't have the time, so they had to prioritize. They had to get it done over the weekend, and there's just no realistic way to do all of these testing of both of these different things. John Beattybot. I know somehow lack of dog DNA came in through Hank Dr. Russell, but does that include or exclude the pig DNA found? Seems unfair if only half the story. Thanks. So my recollection of this is that Hank did bring out the pig DNA. My recollection is that that did come out, but let me get to my notes. See if I can find that part in it. Okay, gotta find the right piece. My notes are such a mess here. Got a little behind on handling anything. I like to like summarize stuff, the like main takeaways. I just lost the ability to do that here. Not seeing in my notes quite yet where that came up. Let's see here. I think it must have been day 26. Did you have any memory issues? No. Okay. I think we're getting close. Okay. So I see the argument now on the dog DNA. So I know it's happened. Got all this stuff. Did you consider this? Did you consider that? So I think I'm in the area. Sorry, this is taken me a minute to get to and try to find. Guys, I am not finding it in my notes. Sometimes, when you look at stuff too many times or whatever, and you're like, your eyes start to cross. It's why you shouldn't like try to proofread your own thing that you filed, because you stop being able to see it. I am not seeing it where it is. Okay, they had the argument. There was the motion for the mistrial. We had the little bit of voir dire. Dog bite can produce lots of saliva, broth. They can shed hair. Saliva can contain DNA. She's aware the criminologist swabbed the sweatshirt. It was done many weeks after the death and the clothing was on the floor. Was that gratuitous answer part of your advocacy? Was asked by Brennan. It was objected to and sustained. Just in case you forgot, like, how long this insane commentary had been going on in this trial. UC Davis, no dog DNA found. Pig DNA was found. No idea where pig DNA came from. I explained why there could be no dog DNA found. One example is that possibility is that the samples degraded. The best practice is to come up with reasons why dog DNA would not be found. She didn't initially know about the dog DNA when she found, or the absence of dog DNA. She when she found out about it, she reconsidered, but she didn't change her opinion. The swabbing should have happened immediately, and she doesn't know anything about the chain of custody of that. She would normally expect a dog bite on the sweatshirt to leave DNA. So that, I think, is pretty much all that I can find about what was in there about that particular subject. So the pig did come in. She did mention wasn't dog, it was pig. So the defense can use that, I think. I don't think it was a situation where they got half of the story. So that at least is something they have to go with. Thanks for sitting tight while I had to sit and stare at my notebook for way too long. Z, did you see Turtle Boy interview with alternate juror yesterday? I did not. I did see that he was going to have the opportunity to do that. He had it set up, but I didn't get a chance to watch it yet. Was it good? Was it good? Was there some tea in it? Was this the one that we knew as juror number 4? No, juror number 4. Oh, I forget who was who. I lose track from the first trial. I'm like, ooh, Victoria George. No, it wasn't Victoria George, obviously. I didn't see it. I will go check it out. Bino, jurors have a trial within a trial. We're not dur. The trial within a trial, when the lawyers are talking about that type of thing, they're talking about an issue being collateral. They're talking about it so far removed from the core issue that the jury has to decide that it doesn't make sense to go and have. You don't go have a trial on whether somebody, hypothetically committed perjury in Australia related to bringing their dogs into the country. When that's, their credibility is an issue in the case, but that particular act is a little bit collateral. So you'd have to have a whole trial within a trial because she ended up not being convicted of it, but did admit it, but sort of didn't. And Kevin Murphy, back and forth, that type of thing. That type of thing is the trial within a trial. Melissa Garcia, who's worse, Brennan lying or Lally's complacency? I'm gonna go with Brennan's lying, generally speaking. In my view, the person who actually commits the wrong is worse than the people who acquiesce in it. Maybe only marginally, but it is worse because there's nothing to acquiesce in if they hadn't done it. Just my personal opinion. From the legal perspective, they're both responsible. They both have a duty to correct knowingly false information. So there really isn't a difference. And let's not pretend Lally hasn't lied either. He totally lied about the handling of the the communications with the crime lab over the DNA testing. He totally lied about that. Really iffy on how truthful he was about the Sallyport stuff. I gotta wonder if maybe that's why Lally hates his guts. Because Hank came in and kind of threw him under the bus with all that, right? Lally's the one who signed the certificate of compliance in the first trial, saying he made a diligent inquiry into the discovery. It's all there. It's all been produced. And then lo and behold, there's this Sallyport video that starts to emerge during the first trial. But not all of it, just some of it. And some of the stuff that should have been turned over, like the video of Brian Higgins, admissible for impeachment, Brady material as to Brian Higgins, didn't turn that over. So all that kind of started getting outed with Brennan going in and sniffing around. I gotta wonder if maybe that's why Lally hates his guts. They're going to hate each other equally, right? If you got a prisoner's dilemma problem. You guys are both over here with your sketchy approach to this case. Don't trust each other. Z, what was moment where you realized justice isn't real? I mean, very, very early on. Very early on. I don't know if there was a particular moment or if it was just a dawning thing that after, you've seen case after case after case go through the system and there's no, what are you getting out of it? Seeing the people come back out of the system and, they're where they were, if not worse off, than they were when they went in. That there's been no real effort to resolve the underlying problem with the criminality. Whoever was harmed by the crime is still harmed. That's not made up for. I mean, I think it was probably just it accrued over time. You keep waiting and you keep hoping to see people, It's not that it never happens. People do. There are people that turn their lives around. But it's really in spite of the system. It's really in spite of the system, not because of it. Because they have the internal motivation to make the change. The system rarely does anything to help them and often does a lot to get in the way. Set them up for failure. Don't know that there was a moment. I think it was just, you start to see the volume. I'm telling you guys, if you all went down to your local courthouse one day a week, I'm going to recommend Monday morning. Little project I've had in my mind, back of my mind for a long time, many, many years. Every court in the country has a docket on Monday morning. Maybe they push it to the afternoon sometimes, but it's usually Monday morning because they have to deal with everybody who got arrested starting Friday night after the court closed. There's typically short time frames to get people in to request bail, determine if there's probable cause, stuff like that. So get arrested Friday night, you're back in court Monday morning. Just watch that and watch the volume of what goes through. How much victimization there is, how much repeat offenses, there are. A lot of that type of stuff. How many of these same shenanigans from law enforcement you see over and over and over again? How much chippy stuff? I don't know, guys. You just you see it, you watch it for a while, and you know, maybe you'll have a different opinion about the system if you go and get your big sample. I mean, thousands of my own cases go through, but you sit in a docket, you watch everybody else's cases go through too. Probably tens of thousands of cases I've watched go through the system. That's really what it's based on. How many times has justice been done? There's no case that I can point to, even ones with like positive outcomes and stuff like that, where I'm like, oh, justice was done here. Maybe an adoption. Everybody likes an adoption. You overlook the reason why you're doing an adoption in the first place, right? There's some kind of trauma there. There's some kind of dysfunction there. But even a good outcome. Karen gets acquitted. Let's say Karen gets acquitted tomorrow afternoon. The jury gets the case, and within an hour they're back and she's not guilty, not guilty, not guilty, and she's done. And what does she get? She gets to walk back to the smoking crater of the ruins of her life. She'll never get the time back. She'll never get the money back. She'll never get the untainted reputation back. She's always going to carry that poison of having been accused. That's not justice. That's not justice. Stacy Labruno. A potential concern is that many jurors tend to want a definitive answer as to what happened. If they don't get it, they may default to guilty even when faced with scientific evidence to the contrary. I do think that is that's a burden that the defense has to deal with. The jurors want to get it right. They want to know. They want to be as sure as they can possibly be. But it's like, if you don't know what happened, then how can you be sure about anything? And that's where it's just on the defense to do what they can to keep bringing it back to the way the system is set up is not for you to be the crime solver. That was the police's job. That was the police's job. And so if they didn't give you the tools that you need to know beyond a reasonable doubt what happened to John O'Keefe, that is not your fault. That's their fault. They are responsible for that. Karen is not responsible for that. You, the jury, is not responsible for that. It falls squarely on the lap of the people who had the power to ask the right questions and get the evidence. And they fell down on the job. They didn't do that. It is. I think this is a very normal human implication. People don't want to let somebody guilty go free. So if they're not sure, they're hesitant. And that's one of these things that I think separates good defense lawyers from really good defense lawyers is the ability to be able to give let the jury feel comfortable taking permission to place the burden of knowledge, of truth, of producing that to them where it belongs, on the Commonwealth. Hold them accountable if you don't know. You can't hold Karen accountable for not knowing. You're absolutely right, Stacy. They do. They want to know. And it's very unsatisfying to not know. So we just got to make sure that it's clear that it's the Commonwealth that let you down here. Ida Van Schalkwyk. I did my best with that one. Ida Van Schalkwyk. Just a big thanks to you for your coverage and hard work. Really appreciate it. Well, thank you so much. Appreciate that. Thank you for being here. Melissa Garcia, more gardening videos. I need to see your garden. Oh man, I'm I'm not proud of my garden at the moment. Like I said, barely planted. I mean, You know, I normally do the kind of normal vegetable garden, the lettuce, I grow all kinds of stuff, the tomatoes, the peppers, the cucumbers, you name it. We like to grow all that stuff. Haven't done any of that this year. Just haven't had the time to do it. Got behind on my fruit trees, my apricot trees. They have these. So I don't like to prune the way that the commercial orchardists prune their trees. They do all their pruning in like January, February. They do winter pruning while the tree is dormant. And that's because they don't care how their trees look. They just care about the fruit production. It's easier to see the limbs and what you're doing and stuff like that when the leaves are off the tree. So it's easier to get to stuff. So there's practical reasons why winter pruning makes sense for commercial orchardists. I don't like it because the tree responds differently to being pruned when it's dormant, to being pruned when it's in it's actively in like an energy positive state, when it's photosynthesizing and producing its own energy and so forth. And so what tends to happen, you go and you prune the tree in the winter. Tree is not actively producing energy. It's not photosynthesizing, very, very little. All of its energy is stored in the vascular system and in the roots of the tree. Then when spring comes and things start to get warm, all that energy starts to come up out of the tree. It spreads out and it stimulates your first leafing out and push of growth that you see in the spring. The energy that the tree has stored in the winter, you can think about that as like a constant, right? It produces so much energy from these leaves, and that's a fixed amount, and it goes in over the winter, and then it doesn't really use it. It's storing it up for purposes of having that growth in the spring, and the growth is all coming from the buds of the tree, the nodes, the buds on the tree. So when you prune a tree, you're taking out a lot of those buds, a lot of them usually. And so what that does is then it means when it comes out in the spring, you have the same amount of energy coming out, but it's being fed into fewer and fewer buds. And so what that tends to happen then is you get very strong vegetative growth from those buds. You see it's suckering. Sometimes people call it water sprouts. Sometimes people call it, you just get this very aggressive vegetative growth. And that's not what you want when you are growing fruit trees. You know, for one thing, you want more fruiting, but it also isn't, it doesn't look good. It's not pretty. It's not pretty. I'm pruning my trees in part for aesthetics. I want to have a pretty orchard as well as one that produces fruit. I don't care about like maximizing the fruit yield or minimizing my labor costs or anything like that. I also want a good looking tree. So because of that, I don't like doing a lot of winter pruning. I like to do more of my pruning in the summer because in the summer the tree is in an energy positive state, and it's much easier for it to readjust and kind of like shift around where it's sending its energy than it is with that first initial burst in the spring. So anyway, having said that, way behind on my pruning, and my trees are a mess. I didn't get a lot of them thin, so there's a lot of hanging branches and things like that. It was windy today. Probably some of them broke out there. I don't know. I'm going to have to go. I'm dreading a little bit, taking a look. Not going to promise videos of gardening, Melissa, unfortunately. Maybe more bonsai. The bonsais are in pretty good shape. TB85, I'm pretty sure Hank said Ms. Reed looked into her rearview mirror, put her vehicle in reverse, and slammed her foot on the accelerator or something to that effect. Seems pretty intentional to me. It does, but he's making that fine line between intentionally engaging in this act and intentionally, specifically having the intention of doing this act to kill him. Murder, specific intent murder is whatever it is that I do, I intended to kill him. Not just I intended to do some intentional act. Sometimes the things go a little bit hand in hand because you can infer you had the specific intent to murder somebody based on what that act was. If my act was to, take a knife and, I don't know, like Dr. Wolf suggested, jam it up into somebody's brainstem. You can infer the logical and probable consequence of doing that is that they're going to die. And so you can infer that by my doing that, I knew that, and therefore I intended to do that. I intended to produce that outcome. So sometimes they go hand in hand, but sometimes they don't. Sometimes I did something intentionally. Maybe I intentionally, like, I don't know. Let me think. Let me try to think of an example. How can we make this work? Maybe I intentionally get in a fight with somebody. I intentionally get in a fight and I intentionally throw a lot of punches. And it turns out I beat the person so badly that they get, major brain injuries and they die. I intended to engage in the fight, but did I intend to murder them? It's not necessarily going to follow from being in a fight that somebody is going to die. So you can't necessarily make that inference. Intent murder is specifically you intended to murder him. But this version that they're relying on is you did an intentional act. And that act itself was just so reckless and so likely to result in somebody's death, and you overlooked that. So it's a little bit of a minor nuance. She doesn't have to have intended to kill him. She just has to have intended to do these things, knowing that there would be a high risk that somebody could get seriously hurt or killed as a result. Maybe, I mean, you tell me, is this hair splitting? Is this lawyery kind of hair splitting? But that's the difference between it. I agree. His description of it sure makes it sound like he's saying intentional murder, and that's what Lally relied on last year to argue it was intentional murder. She did it. She knew it. She knew what she was doing. She knew that she left him. Just taking a different approach, I guess. Amy McCammon, Aperture makes Bev POTY, conflict of interest. Oh, their contribution to the attorney, the bar dinner or whatever it is. No, it's not going to be a direct conflict of interest because that money is not going directly into Bev's pocket. It's extremely unseemly, very unseemly for a court to be going in and accepting awards at a function that is being paid for by a witness that's appearing in her court. Doesn't look good. But in and of itself doesn't create a conflict of interest because that money it's not going directly into her pocket. She's just getting some kudos at a luncheon that, at least in theory, somebody would have sponsored it if Aperture hadn't. It's not directly tied to what they gave or anything like that. So very unseemly, not a good idea. Lots of judges, probably in the interest of discretion, would have declined that invitation. But no, it's not a legal conflict of interest of the kind that could get her thrown off the case. TB85. Kant in his opening, apologies. I must have missed the first part of your comment, or I already forgot it or something. So sorry about that. No apologies needed. Thanks for the comment. Michelle J. Piggyback on my last question. Are jurors allowed to take notes in their notebooks during opening and closing arguments? P.S. Thank you for all you do, Andrea. I adore you and your commentary. Oh, thank you so much. It's such a sweet thing to say. So you might remember back to opening, I'm pretty sure they weren't even given their notebooks before opening. They're told the openings and the closings, the lawyer statements, they are not evidence. So I'm pretty sure they weren't even given the opportunity to take notes during the opening statement. The closing, that's a good question. I'm not sure. I don't remember seeing anything in the model instructions that tells them you're not allowed to take Take notes during closing. Now let's just go ahead and look. It's in here. Let me find it. Juror notes. Here's what they're instructed as far as their notes. Many of you have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony, but of course they are not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Whether you took notes or not, you must rely on your own memory of what the witnesses told you. After the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. So it doesn't say specifically in the instructions. You know, this is a good question. I don't actually know if they're going to be allowed to take take notes during the closings. Remember, the notebooks all get taken into custody of the court officials, the bailiffs. And they do whatever they do to secure them and then hand them back out the following morning. So it may very well be that the bailiffs will simply not give them their notebooks before the closing tomorrow morning. I'm not sure. I don't know. I don't think they would be given their notebooks and then just told don't take notes. I think if anything like that happens, they would just not be given their notebooks until they're going back into the deliberation room. Just not sure, not 100% sure. If they were being consistent with the opening, you just wouldn't give them the notebook. You keep it away from them. Don't give them the opportunity. Yeah, great question. Great question. Wish I could answer it better for you, but I'm not actually sure. Trying to remember. Don't remember anything like that coming up in the first trial. She would have said something. I don't know. I guess I don't even know if we'll find out because, of course, we don't see the jury. We won't see. So unless the judge says something about like, you know, you'll have your notebooks back when you get into deliberations or something like that, maybe she will. Or unless somebody in the courtroom tells us if they have their notebooks or not. I don't know if we'll know, but we'll keep an eye out, see what we can find out tomorrow. Carson Pratt, when you say nobody wants a quitter, it makes me think of a saying about quitters and what Hank's mom should have done. I mean, you know, look, quitting is going to get you scratched from the roster, from the lineup really early on in your competitive career. Okay, you can train a lot of things. You can train a lot of skills. You can't train heart. You got it or you don't. It's one of the things I said many times I love so much about boxing. It is the most honest sport. And it's ironic to say that because, you know, it's rife with corruption and stuff like that. I mean, got nearly thrown out of the Olympics because of, the corruption with the governing bodies and stuff like that. That's really not what I mean when I say it's honest. No, it's always been run by the mafia and Don King and, you know, people like that. Definitely not what I mean. I just mean it's honest in the sense that there is no hiding. There's no lie. You can tell yourself whatever bullshit story you want about how good you are and how tough you are. You get in that ring, the truth is gonna be revealed. It's gonna be revealed and you're gonna find out and everybody else is gonna see too, the truth of all that. It's such an honest sport that way. So somebody doesn't have that dog in them. Mm-hmm. You see, you find out and you're not going to last long. You're not going to last long in the sport. I mean, why would you want to anyway? Barring a humiliation fetish of some kind. Why would you even want to? A lot of people want a fighter, but nobody wants a fighter that quits. Nobody wants a fighter that quits. 40 Doherty. Wait, I thought Commonwealth X'd lesser included's not the defense. Does the defense have a say in what's charged. Both parties can ask for lesser included offenses. The defense doesn't have any say over the indictment, and they don't have any say over, like, charges being dismissed or not submitted to the jury. They can argue the evidence isn't insufficient, like they did. It almost never wins. Sometimes it does, but most of the time it doesn't. But other than that, their only control over the charges is they can ask for lesser included offenses. And so a lesser included offense is any lesser charge that would necessarily have to be proven to convict you of the greater one. And where it comes up most obviously in this case is with, for example, the vehicular homicide, the manslaughter, the voluntary manslaughter by operating under the influence. You necessarily have to prove operating under the influence. So either party could ask for that as a lesser included instruction. Manslaughter just requires, the additional elements of somebody died and, all those other things that are in the instruction. So either party could ask for that. That's pretty well established. That's pretty normal. In some states, the Commonwealth does not. The prosecution doesn't get to ask for lesser includeds. If they want a lesser, they have to charge it or they have to go to a jury. But I'm pretty sure that's the minority rule in most places. Most places, either party can ask for a lesser included instruction. Michigan farm boy, catching up. Weren't the kids' names supposed to be kept out? And Bev just went and called out the niece by name. No jury, but on stream. Yep. You're absolutely right. There's a decorum order in here that nobody is to use the names. Not even Bev respects her own rules of decorum in her courtroom. Emily, do you think Lally is doing defense? I think you mean prosecution. He's definitely not doing the defense closing. Is he doing the Commonwealth's closing? I doubt it. Remember his closing last year? Those of you who watched the first trial, remember his closing last year? Remember how he just sort of like, it was one of those, like when you watch the track meet and somebody like, stumbles and falls and like somersaults over the finish line. It was rather like that. He just sort of ran out of time. Bev had to cut him off, warn him that he's being cutting off. He still couldn't finish. It was pretty pathetic, really. It was rather pathetic. No, I think it'll be Brennan. He's better. He's better at that type of thing. He would do a better job than Lally would. He is the special prosecutor, not Lally. If he's given up that bad, maybe, but I doubt it. We're in there letting Lally handle the instructions conference so that Brennan can sit there typing away on his laptop right in his closing. That's my guess of what's going on. So no, I'd be very surprised if Lally ends up getting up to do the closing argument for the Commonwealth. Next witness, Andrea. Thank you for your amazing analysis of every trial you cover. Thoughts on a verdict tomorrow if their schedule stays on time? I'm afraid to hope for it. I am. Of course, we'd love that. Of course. It would be so vindicating. Feel like it would be the right thing. It seems very obvious. But you just never know what the jury is going to do. Don't know who's on there. Don't know what their thought process is. It's not unheard of sometimes. I mean, I've heard anecdotal stories. People on jurors are like, yeah, we had the case decided within like 5 minutes, but we figured we might as well wait and get the free lunch that they were going to provide for us. We didn't want them to think that maybe we didn't put enough time into it, did something wrong legally. Didn't want to hurt anybody's feelings. So we just sat around and shot the shit until, the end of the day or something like that. It's not unheard of for stuff like that to happen too, but it's just rare that you get a rapid turnaround after a, 30-day trial, 31 days of evidence. Just rare to get, within an hour. Within a couple hours. I'd love it, but you just can't say it's likely. So I'm afraid to hope for that personally. The algorithm leaks. Why do you think they handpicked Brennan? Because he gave them exactly what they wanted. They knew exactly who he was. He's not an unknown. He's not a mystery. This isn't the first time his tactics have been on display. They handpicked him because they knew he'd be shady as shit. His ethics are questionable, and that's what they wanted. That's what they wanted. Z, any investigation on Bev denying all defense Daubert Lanigan and voir dire motions for Commonwealth experts despite having all their insufficient reports and PowerPoints and help Hank Brennan elicit false hoodie and x-ray testimony to jury? There's not going to be any investigation at all. None at all. Certainly not of Bev. Bev is the last person who would be investigated. The only possible, issue out there for any of this would be requesting an investigation into the hoodie, the misconduct, the misrepresentation about the hoodie. What exactly did maybe the x-rays. But the hoodie, what did Hank know? When did he know it? And basically same thing with the x-rays. How did that misrepresentation get made to the jury? Who was responsible for that? But Bev's not granting those hearings. Okay, she wouldn't grant an evidentiary hearing on the misconduct relating to the Sallyport stuff, where the shenanigans are obvious and stuff has been withheld for years, and we're still not getting consistent explanations about what happened, who got it, where it was stored, why it's piecemealed out, all that stuff. Very incurious court about those types of details. So no, this will be the end of it. Unsatisfying, huh? Tribal girl, the FBI is the new F word in Bev's court. Yeah. Ain't gonna be nothing to open that door, apparently. Not here. DKIT, the overlooked tragedy of this case is if Karen didn't do it, who did? And the reality that whoever did kill John already got away with it. It's the common theme of every case where we're gonna focus in on one person, and turns out we got the wrong person, but we've got our tunnel vision and we're locked in. This is the tragedy of every case. You don't know who the real person is. There will never be, to the extent that any of this is justice, right? I would like to think that at a bare minimum, the justice that the trial process is supposed to, that we can, or that we should be able to count on, is that it gives us the truth about what happened. Aspirationally, in practice, of course, it's maybe asking a little too much, but at least aspirationally, that's how you do justice for the wronged, is by airing what happened, revealing what happened, and allowing us to see those who did it. Charge the wrong person, dig in, refuse to adjust. No, you never get the right person. And so you never have justice. Agree completely, DKIT. Phil the Gilbert villain Biggs. Andrea, bring back your top pony and channel your inner Barbara Eden. Whittle your legal nose and bewitched us a not guilty in 30 minutes. I need a headband. I don't have a headband. I'm not a cute blonde. I don't have the blue eyes. Sorry, guys. Bewitching is not in my skill set. Well, I mean, maybe if I was doing the closing, I could, no, I'm just kidding. That's the opportunity to work your magic. It really is that chance that you have to address the verdict. So don't hope that for me. Let's send all that energy to probably Mr. Jackson. We think it's probably Mr. Jackson. Or is it Mr. Yannetti? think it's probably Mr. Jackson. We'll see. But whoever on the defense team is going to be in that position to cast that spell, let's wish it their direction. They're the ones that it might actually, they might actually be able to get to do that and pull that off. Spencer, going into final round, notable difference versus first bout. I mean, definitely, I feel like a different end this time, which is kind of funny because last time we ended on the ARCCA witnesses as well, but we didn't have all this additional testing. We didn't have them, squarely stating multiple times. There wasn't a collision here. It was much more just not consistent, and there was that sort of muddying the waters a little bit of the cannon that they did to shoot the tumbler at the tail light. Like that really came out of left field because nobody's been asserting that as a theory here. And so it hadn't, I mean, it's probably crossed some people's minds, but it just hadn't featured at all in the case until it came up through the ARCCA witnesses. They were a little bit of a mystery because nobody had been able to talk to them. FBI kept them under lock and key until they ended up on the stand. Their report got provided, but the witnesses themselves. So I feel like we had a similar ending in that they ended on ARCCA and there was no rebuttal, no rebuttal from the Commonwealth. But I just feel like this was a much more disastrous conclusion this time relative to last time. I mean, I don't know how you finish the case with a defense witness who said like no less than 5 times an expert biomechanist. I don't think there even was a collision. I don't know how you end the case on that. If you're the prosecution, I really don't. You gotta have some serious quit motive to stop there. It's crazy. Last thing that the jury heard and that resonated with them. The first trial, they might be thinking, weird tail light cannon. Hadn't really thought about that. Maybe that. And so you already have the case set up in a way where the jury is thinking about what happened. Did what the defense claimed happened? Does what the Commonwealth claimed happen? Was there something else that happened that nobody's claimed, where maybe it was, so it fed into that tendency that was, already brought up and talked about to want to solve the crime, want to know the answers and figure it all out. This case, I think, is quite a bit different. It hasn't been positioned that way, and it's positioned much more squarely on the Commonwealth's burden. Also, really got to give the props again to Dr. Rentschler. Dr. Rentschler, he's a real one. Okay, I bet if he's a Commonwealth's witness, a prosecutor's witness, he might not be, unless he does have the proof, right? If he's got the proof, but pointing out. You need the evidence to prove it. If you're trying to say something happened, you have to prove it. Him bringing that very basic point back to the jury. Oh yeah, it's the Commonwealth that's alleging something happened there. They have to prove it. And what have they done? They've thrown up their hands and said, it's too difficult. We'll never know. Well, that was their burden. Just energetically speaking, very different finish this time around. The first one was much more of a go to the cards, and it's a close decision. A lot of rounds traded back and forth. This one is just, I think there's been a lot more dominance on the defense side. Ricky Daly 12. Just like you walked us through a summary of the Commonwealth's witnesses when they rested, can you do the same for the defense witnesses? Rick Daly, I would not be against this, but the problem is, like I said, what I had been doing and what I like to do is I take all of my notes, a lot of detail during the day while we're watching the trial. And then when I get a chance, I go in and I summarize them. I do like a little recap for myself of just pulling out what are the main points, what are the main takeaways, because my notes. Here's my notes on this trial right now. Okay, this is my notes. Then actually this is in it too. Okay. That's what I got to try to sort through to keep track of stuff. And I'm behind. I haven't been able to do that for the defense case yet. Time has been limited and I have prioritized other things than that. So I don't have my summary ready, and I'm not prepared to go through probably 10 legal notebooks to try to sort out the defense witnesses. We got a good summary from David Yannetti during the motion. Today's motion to I keep forgetting what they call it. Motion for not guilty verdict. What do they call it? Motion for required finding of not guilty. Dr. Russell, Dr. Laposada, Arco, Barros, Kolakithis, Lucky. And then we also had, the investigator with the photos and so forth. Yeah, that really was their case. What did we get? Dr. Russell, these are dog bites. Also, nothing here looks like a motor vehicle collision. Laposada, I agree with that. Animal bites, absolutely nothing here looks like a motor vehicle collision. ARCCA, nothing here looks like a motor vehicle collision. The force that would be necessary to break the taillight wouldn't be generated by the impact that the Commonwealth has posited. Would not be enough to get to that underlying diffuser parts of the taillight. And also John's injuries John's injuries, period, are not consistent with being hit by a car. But given the forces necessary to break the taillight, had those acted on John, it would be a very different situation we'd be looking at. Nicholas Barros looked at the taillight. In the photo of the taillight in the Sally port, it was absolutely not in the condition that he saw it when it was in the driveway in Dighton. Karina Kolakithis, I was out at the bar at the waterfall. There was no, Karen seething over John. In fact, it was the sweetest thing I'd ever seen. John giving Karen that kiss on the forehead, which incidentally happened to be right in front of Brian Higgins. Higgins, and then Lucky Loughran. John was not on the lawn. I was out there with the plow. He wasn't there, but then that Ford Edge showed up. So that's the 20,000-foot view of the defense witnesses. Can't give you more detail right now. Sorry. But David Yannetti did a good job. Brian Tracer, I used to believe the number of innocent people in jail was a rather small percentage. In recent years, that belief has been shattered. Yeah. It's real tricky because a lot of times there's degrees of this. There's degrees of this. There's a ton of people, from my perspective, who are in jail for the wrong crime. It's not that they didn't do anything, but they got upcharged and they got leaned on, and they got caught up in the system and in various ways where the pressure is put on them. They're innocent of what they were charged with, but maybe not like innocent of any and all criminal activity. There's a lot of that, I think. People who are actually innocent of any and all criminal activity, we don't like to think about that, do we? We don't like to think about that because that means we in the system, we have victimized those people. Those people are victims of the system. And sometimes they're horrific. Sometimes it's horrific victimization. God, the Cameron Todd Willingham story is one of the worst, one of the absolute worst. It just is horrifying. Man loses his family in a house fire and then, gets accused of committing the crime. gets railroaded, convicted, and executed, put to death. Put to death. And what do we know now? Oh, it's largely junk science. And a lot of, just the same story you always hear with the innocence cases. There's tunnel vision, there's prosecutorial shenanigans, there's bad eyewitness, all of these things, they just come up over and over and over again. And so it's starting to become a well-known pattern. And we don't like to think about that, because it's often not just we're victimizing people who are innocent and don't deserve it, but we're victimizing people who have suffered enormous tragedy. Look at like the shaken baby cases and stuff. Shaken baby, junk science. Junk science. Some doctor comes in and says, "Oh, this I got to be technical here." When I talk about shaken baby, I'm talking about specifically diagnosing that a parent caused, I want to say it's like a brain bleed. Now, of course, I don't have the details front and center in my mind. Lots of different ways you can look at, did a parent kill their baby, right? Does the baby have fractures? Does the baby have, other types of injuries? When I talk about shaken baby, I'm talking very specifically about they are just looking at acceleration type brain injuries. There's no other indication of any type of abuse of the child. And they're saying the parent shook that child and caused death. We've learned in the past, like with a lot of these sciences, few decades, that premise, it's no good. In fact, it's never been good. They've known since the 1980s. There's studies in, I think it's the British Journal of Medicine, something like that. The foundation for shaken baby syndrome has never been solid medically. And so just imagine that. You find your child dead. What they've learned is that these injuries can be caused by significantly less force and less like movement than we previously knew. So kids can, in fact, like fall off the couch, suffer a major brain injury. You wouldn't necessarily think so, but it's just because of the, condition of that child, and they're less resilient to that type of injury. So, just imagine that. You're a parent, you've lost your child, and now you're getting blamed for it. It's horrifying stuff to think about. Yeah. A lot of prosecutors' offices now are starting to do this. They're adopting what they're calling like post-conviction integrity units, which is better than nothing. Definitely better than nothing. The idea is that you have this like special prosecutors that come in, and all they're doing is reviewing past convictions, cases that have already gone through, and they're looking for issues, the kinds of things that come up in these exoneration cases. Is there misconduct? Is there junk science? Is there anything else in this file that should call that conviction into question? It's better than nothing having that type of review. I'm skeptical. I'm often quite skeptical of post-conviction integrity units generally because, what's the incentive of the employer? The incentive of the employer is to, either cover it up and bury it or minimize it, make it a no big deal kind of a situation. Just not personally really assured that is doing the job of, making sure that past convictions are valid, are sound, shouldn't be relooked at. But it is better than nothing, I'll give it that. So small steps, guys. It's taking small steps. Better than none.